Lordship, I wish to mention item number 7. This matter may be adjourned for today and taken up for 3 weeks. This matter may be adjourned for today.
You are for which party?
Petitioner,
Petitioner. Why do you want adjournment?
we have to file our reply.
We have filed our affidavit, my lord.
Respondent number 4.
Yes, 1 to 4, yes.
What about others?
Others, my lord, they are not here.
Others will not be filing? Okay, please write. Learned counsel for the petitioner prays for 3 weeks' time to file reply to the affidavit in opposition filed by respondent number 4. Full stop. Next parent view for above, matter stands adjourned for 3 weeks. Full stop. Parties to exchange their pleadings in the meantime.
May it please, your lordship. Lordship, I beg to mention item number 8, your lordship.
Yes.
Learned PP is taking up this matter, your lordship. However, he is out of station for some medical emergency, your lordship. If I may pray, may this matter be listed on 29th, your lordship.
Who's the PP?
Jay Shring, your lordship.
Sorry?
Jay Shring.
JC. You're for the, you're
Yes,
for,
I'm for the appellant, Your Honor.
this is not a jail appeal, is it?
No, your lordship.
You allow them, brother? You allow them? You want some time? The learned PP, Mr.
Jay Shring.
J. Shri,
Shring.
J. Shriam. Where is his name? Is not shown here.
Your lordship, PP's name, only reflection of the designation is being shown in the cause list, your lordship. PP of
Okay.
IP.
Then you write the learned public prosecutor is reported to have some personal difficulties to appear before the court today. To stop on a mention made on his behalf and not objected to by the other side. List the matter for hearing again on
29th, your lordship.
29th of August.
Yes,
All right.
I'm deeply.
I beg to mention item number 5, my lord. The leading counsel here is on leave. This
Who?
matter may be taken up on this 25th of this month.
On
25th of this month.
25th of
Friday.
this month. You have it the coming week. This has come for the first time, isn't it?
Yes, it's on admission.
It's for admission. The
Yes.
first time listed for the first time. You have it on Monday or Tuesday.
All right, in Monday.
All right.
Worship.
The learned counsel for the appellant is reported to be out of station. To stop on and mention made on his behalf that the matter be listed again on 28th of August 2023.
My lordship, item number 1 to 4 is analogous matter. Basically, in this case, the petitioners, they were detained under Apu Apa. And then they were detained almost, some are detained for 9 days and some were detained for 27, 29. But now they have been released during the pendency of these writ petitions. But then we wanted that this writ petition should be dispersed because the way they have detained, but we are challenging that it's illegal. Illegally they were detained. Whereas Apu Apa cannot be applied against the petitioners in this case. But then this law was applied against the petitioners and then they were illegally detained. That was our challenge. But then before this disposal of the writ petition, all the writ petitioners are released.
Okay, but
Lordship, we have
what
received
is
the
your-
instructions. We have to file affidavit, your lordship. We need some time, your lordship.
though they are released, you are still pressing.
Yes, my lord.
Okay, then let them file the affidavit. When will you file your affidavit?
Lordship, 3 weeks, your lordship.
Mr. S. Mao, learned counsel for the petitioner, submits that the petitioner was illegally detained under the Arunachal Pradesh Unlawful Activities within bracket Prevention Act, 2014. Full stop. He submits that though he has been released during the pendency of this writ petition, the petitioner would like to press the matter, since according to him, he has been illegally detained under the said provision, under the said law. Next para. Ms. R. Basar, learned government advocate, submits that she may be granted further 3 weeks time to file counter affidavit. Full stop. Next para. In view of above, matter stands adjourned for 3 weeks. Respondents to file their counter affidavit in the meantime.
Obliged.
So similar order will go in
Yes.
the remaining
Yes,
one,
Till 4, lordship.
2, 3, and 4. Same orders, sir.
obliged.
Obliged.
My lordship,
Yes.
this is application for condonation of the lordship,
Ah.
344 days. And filing connected with that lordship,
How many days?
344 lordship,
344.
344 lordship.
For filing what? Writ appeal.
Writ appeal lordship,
So delay has not been condoned till now.
not yet lordship.
Let's see. Now who is appealing for the other side? Yes, you have objection?
No, your lordship.
You have no objection.
We have not filed any objection, your lordship.
You have not filed objection.
Yes, lordship.
And
My
any
lordship,
other,
private respondent has filed objection lordship.
where is private respondent? Who is appearing for that?
Senior counsel, Mr. M. Patil lordship.
Hmm?
Senior counsel, M. Patil.
M13.
M. Patil.
He has not come today. You were the writ petitioner or the private respondent
Private respondent
in the writ petition?
in writ petition
I see.
lordship.
What was the verdict of the learned single judge?
Learner single judge has lordship set commendation of DPC lordship, whereby I have been promoted, retrospectively promoted to the post of executive engineer, civil
Uh-huh.
lordship. Whereas,
Your
Yes,
promotion has been set aside.
set aside lordship.
Okay. So what do we do? Government has no objection, but Mr. Partin has filed written objection.
Yes, sir. Basically, they has objected lordship. I have not made a specific amendment for the 56 days of delay lordship.
Sorry?
For 56 days of delay lordship. Affidavit was shown on lordship 9/9/2022 lordship. And I have 9/9/22 lordship.
You know, what are you saying? I'm not able to understand.
Lordship, basically they had objected that I have shown the affidavit on 9/9/2022 for this IA,
Hmm.
and I have filed it on 4th of November 2022 lordship.
Okay.
I have made no amendment for the explanation of 56 days lordship.
How many days?
56 days.
In between, there are 56 days.
Yes, lordship.
9/9 to 4/11. How is that then? What is the explanation?
Sorry to insult lordship. I have no made any
What is it?
explanation.
You have no explanation.
Lordship, October lordship, there was a puja vacation lordship.
Okay.
Puja vacation from 2 to 16 lordship.
Now, where is your affidavit? Let's see. By the way, how many respondents are there? Private respondents?
1 to 10 lordship.
Sorry?
10
private respondents.
10 private respondent lordship.
So they are all represented by Mr. Partin.
13 lordship.
I see.
Para 4 of the affidavit lordship.
Just a minute. No, like you said, affidavit was signed on 9th of September 2022,
Yes, Lordship.
but the IA is filed on 5th November 2022. Why?
Lordship, some document has to be sought from the
Huh?
client, Lordship. Moreover, Lordship, applicant is posted at Jenging, Lordship. Upper Siang, Lordship. It is a remote place, Lordship.
No, that cannot be the explanation.
Yes, Lord.
If you signed the affidavit on 9th September, why did you submit the affidavit, the IA only on 5th of November?
Lordship, they had not, client
No,
had
I'll
not.
tell you, because the seal of the fourth commissioner of affidavit is also 9th.
Yes, Lordship. That I had admitted, Lordship.
When this affidavit was signed by the applicant before the Audit Commissioner,
9, Lordship. 9
Ninth.
September. 9 September.
when the affidavit is supposed to be signed by the applicant, when in the application, is it not the date when the petition is presented before the registry? You find out this is going on for the convenience of the party. Is not it? Find out what the rule says. Is it permissible or not?
The normal course is on the day of filing, the opponent will present himself before the commissioner of affidavit. Counsel will be there, or somebody will be the advocate's clerk to identify him. Signatures given on the same day. Because the commissioner of affidavit is from this high court only, isn't it? So on that same day, he has to insist that where is the deponent, and he'll give a signature. And the deponent will give a signature. The date has to be in one date. It appears that the deponent has come well in advance just to give his signature.
May, Lordship.
And after about 56 days, you file the affidavit.
May, Lordship.
That cannot happen.
Well, Lordship, The applicant was reverted back, Lordship.
Hmm?
Applicant was reverted back to, they had filed, applicant has filed one writ petition, Lordship, 3/11 of 22, Lordship.
Hmm.
And that was moved on 7, Lordship. 7 of September.
Which writ petition?
7, Lordship.
No, we're not talking about writ petition. This is IA.
Yes, Lordship.
You file appeal, correct?
Yes, Lordship.
In appeal, there is no affidavit, isn't it? It's only a certificate given by the lawyer that they're good grounds. That's all. But in the IA is supported by affidavit. So how can the IA be sworn at a very prior in time, 56 days earlier? Thereafter, you file the affidavit.
May, Lordship. Lordship, writ petition 311 of 22, Lordship. It was moved on 7, Lordship, 7 September 2022. On 9th, I have signed it.
Mr. Baum, you have not understood.
Yes, Lordship.
We are not on the merit when this application for condemnation was filed by the applicant, namely the appellant, before the registry of this court.
9, Lordship.
When was it filed?
4th of November, Lordship.
4th of November. On 4th of November, the applicant was present before the Court Commissioner to sign the affidavit stating that the statements made in paragraph so and so is true to his knowledge. This is what we are debating. The applicant was present before the Court Commissioner on 9th of September. You presented the IA in the month of November.
November.
Is it permissible? That is the issue.
Anyway, Mr. Partin is not here today, so we'll adjourn it coming week, maybe. By filing this application, the applicant seeks condonation of 344 days delay. In filing the connected writ appeal. To stop, although the state respondents have no objection to the application, the private respondents, respondent, is it?
Yes, Lordship.
Writ petitioner
Writ petition.
has filed objection. To stop, the private respondent is represented by Mr. M. Party, learned senior counsel, who is otherwise absent today. To stop. Next, para in view of above, let the matter be posted again. When? After a week?
After
Next para. It is noticed that the deponent has sworn the affidavit on 9th of September 2022 before the Commissioner of Affidavit of this court. To stop, the Commissioner of Affidavit has also given his signature with seal on 9th of September 2022. To stop. However, in the cause title of the application, it is seen that the IA was filed on 5th of November 2022. To stop. The applicant will have to explain as to how the affidavit was sworn even prior to filing of the IA.
May I please, your lordship? Lordship, in
Yes.
this, my lord, in this matter, my lord, I have some personal difficulties. My lord, firstly, all the way, my lord, yesterday night I travel all along, my lord, the 400 kilometers from my hometown to my lord, reach Kannada. And another difficulty is, my lord, therefore, my lord,
So you went for a short vacation
my lord,
and you are very
And,
tired.
my lord, this epidemic is writ appeal is bulky, my lord, each and every phase has to be go through, my lord. That is one difficulty, my lord. The another difficulty, my lord, I just wanted to appraise your lordship. My lord, unusual proceeding is going on in this matter, my lord. My lord, may I kindly how this case is very important for the parties and the, my lord, the petitioner, that they time and again has to write a letter to the department, and the department is in reply to that, my lord, time and again written me a letter for appearing before this honorable court. My lord, as per record, my lord, all time, each and every hearing, my lord, I am present. But time and again written, my lord, this is a letter just written by one of my colleague, Madan Mili. He is also the practitioner lawyer. My lord, just I'm
Written to whom? No, you don't, just don't pass it on.
my lord, written to the, my lord, he has written a letter to the DIGP ITB, DGP ITBP and the IG ITBP and Commandant 9th ITBP, my lord.
Okay, stating
My
what?
lord, subject is a request for council presence on the hearing date of writ appeal number 41 and 42, my lord. My lord, this is a case only because of my lord, non-appearance on in the case. The
No.
attribution is, my lord, like it
Mr.
is getting delay, my
Kato,
lord.
Mr. Kato, that you have to sort it out at your level.
So
Why
therefore, my lord,
Why should the court be involved?
but my lord, this is some, my lord, some kind of interference.
See,
my lord.
Mr. Kato, if you say that on each and every occasion when the matter is listed,
My lord.
you are present,
Yes, my lord.
just obtain a copy of the order and give to them. What is this gentleman talking about? I'm appearing on every occasion. This is the order.
Therefore, my lord,
That's all.
and the other hand, my lord,
What do we have to do?
my lord, I have written a letter to, my lord, their representative is time and again present before this honorable court as and when matter is listed. And I have written also letters to them. Please not to send any such documents later.
Good, good. You sorted it out yourself, Mr.
So therefore, my lord,
Mr.
at this
Kato,
place, my lord,
Mr. Kato, you are DSGI,
My-
all right? You are DSGI, so they should take your word for it also, isn't it? So this you can sort out.
my lord, this is something.
Now, apart from that, what about this case today?
My lord, apart from that, my lord, as I have pointed out, my lord, again, I have to go through all the annexes, my lord. Otherwise, my lord, the case is very simple, my lord. There was no procedure initiated from the ITBP requiring body for my lord, acquisition of this piece of land, my lord. All of a sudden, everything has been initiated by the deputy commissioner.
You take your stand. Either you want to seek adjournment or start
My
explaining
lord,
about the
some
case.
more time may be given, my lord.
If you start explaining, then we'll hear you.
My lord. In the meantime, I'll sort it out with the department also, my
Yes,
lord.
there are other-
Or otherwise, my lord,
Who's for the other side? Mr. Mao, all of you are here. Mr. Saikia. He wants time. You want some time?
This has been taken
Ah.
on for last 3 to 4 years for compensation.
Correct.
So
So if you can accommodate him, when will you be ready?
my lord, after 3 weeks, my lord,
Huh?
after 3 weeks, my lord.
3 weeks.
My lord.
Why?
My lord, pendency is not because of us, my lord. They filed, my lord, the first of all, writ petition before this honorable court, and that proceeding was going on, my lord. In that proceedings, my lord, we have raised the objection. No, we have not given the consent for the acquisition of the piece of land, my lord.
Mr. Kato,
My lord.
like you submitted at the first, that since you have come back after a long journey,
My lord.
you need some time to
Madam.
prepare. How can you say that it'll be after 3 weeks? You need accommodation. We consider that, okay,
My lord,
maybe in the coming week.
after 2 weeks. I'll come with, my lord, I'll discuss with the officer concerned also, who is time and again, my lord, sending me the letter. My lord, sending a letter is only because of the council and my lord, the parties, who is written a letter to the my lord, the department, my lord. It is not our case that, my lord, we have not, my lord, we are not present, my lord, appearing in the case, my lord, in none of the, my lord, the hearing date.
So
We
let's
remain
have,
absent, my lord.
we have a date then.
Yes, my lord.
What suggested date? Come to a consensus?
Lordship, I put my appearance on Monday for the first time.
Ah,
Then they seek adjournment.
Hmm.
So it was fixed today.
hmm.
Then again, for second day, without any proceeding, I'll be paid.
Hmm.
So may pray that if he's very tired, and he should not be tired because he's been handling this case for last 4 years. Same compensation.
We don't
same-
have any mechanism to measure his tiredness.
Lordship,
If he says he's tired, then we'll have to
Lordship,
accommodate him,
yes,
isn't
let
it?
it be tomorrow, Lordship.
My lord is only to see whether the my lord Lada Singhuja has, my lord, held my lord, the writ petitions are not maintainable because of my lord res judicata, my lord. That's the only issue, my lord, here.
Mr. Kato?
My lord, tomorrow may not be possible is because, my lord, again, I have to discuss with my lord. This is the things which unusual proceeding is going on, my lord. Therefore, my lord, I apprise your lordship for indulgence, my lord.
No, that's why we have been liberals, but you must give us a date. Otherwise,
Otherwise,
we'll
my
not
lord,
just say that 3 weeks, we
In
don't
that
know.
case, my lord, I'll discuss with the officer concerned.
No. You discuss, but we'll give you a date. Because you're not the only one who is
Next week, my lord.
stakeholder.
Next week, my lord.
That's what. Let's have a date.
On, my lord, 7 Thursday, my lord.
Thursday.
Uh,
Convenient?
If I'm not wrong, next week, Honorable Justice Kardak will be there.
Uh-huh.
So he was a part of this.
cannot take up.
petition. Yeah,
I
yes,
see.
Lordship. So that's why, Lordship,
Uh-huh.
we are playing for tomorrow, Lordship.
My lord. Then in case, my lord, 13 or for 14, my lord.
Merit of the case is requiring authority doesn't want the land, is not it? You don't want the land.
My lord, exactly
You have been forced to acquire something like that.
forced to acquire through unusual proceeding, my lord. We are already in the possession of the land, my lord. This land, piece of land has been taken over from the Assam Rifle, my lord, in the year 2005, when the ITBP was inducted in the state of Arunachal Pradesh, my lord. It is not that case, my lord. We have occupied the land forcefully, my lord, in fresh manner,
Mr. Kato,
My lord.
whether it be Assam Rifle,
My
whether it be ITBP,
my lord.
whether it be BSF, CRPF, they are all under the Home Ministry.
Correct, my lord.
So irrespective of whom is occupying it, you're occupying it. So the Home Ministry has to look into it, isn't it?
My lord, therefore,
So you cannot interdepartmentally fight. It's not us, it's them. Then they say it's not
this
you.
is not exactly
It is
case
not
of the
us who's
press
occupying them,
acquisition,
it's
my lord.
you. So that you sort out, like the one problem which you just mentioned, you sort it out at your level.
My lord.
And even this between the departments in the Home Department, under the Home Department, the organizations, you also sort it out. So it was occupied by the Assam Rifles, well and good.
Exactly one day, land is under the position of the already in with the Assam Rifle that has been took over by the ITBP, my lord, in the year 2005, my lord. And in that, my lord, subsequently, my lord, notification has been issued at the behest of this land affected people, my lord, the so-called affected person, my lord. My lord, the notification was issued not in consonance with the land, my lord, which is already under the position of the ITBP, my lord. The lands are exceeds, some lands are, my lord, less,
All
even
right,
the
all
owners are, my lord.
All right. We'll pass the orders. Now, what would be the conducive date?
14, my lord. Subject to convenience on the part of the other party, my lord. On 14, my lord.
All right. Although the parties are represented by the respective councils, Mr. M. Kato, learned DSGI, submits that he has some personal difficulties to conduct the case today. We'll stop. Next para. As paid for and agreed to by the parties, list the matter. Is it for hearing? For hearing again on
14, my lord.
14th of September.
Let it be on 4th, Lordship,
Why?
4th of September.
No, will the bench be appropriate that time?
Yes, madam.
Yes.
Both.
My lord, 14 is. On 14.
Mr. Kato,
Next week is Justice Kardak and Justice
My
Talia.
lord, yes, I've already put
And-
it out, my lord.
And
only
next-
1 week, only 1 week.
Yes.
Only 1 week,
Okay.
Justice Kardak. After that, next week, from 4th, Justice Tagia and Madam is here.
My lord, otherwise also there is no urgency in the matter, my lord. Amount has already been deposited with the deputy commissioner, my lord. Whosoever, my lord, entitled, my lord, they will get the my lord, the compensation amount, my lord.
Then there should be.
My lord, it is only case of the 2023, my lord.
No, 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 no.
No. It's case
Award
of-
was passed in the year
All right.
2018.
We'll make it 4th, Mr. Kato. You prepare yourself. 4th of September,
Well,
4th of September.
My lord, that is too short, my lord. Or otherwise, my lord, on, my lord, 12, my lord.
You make your prayer on that day. We have decided 4th of September.
My lord.
Can it be taken up tomorrow then? Not tomorrow, I have some difficulties, that is why I'm making, I will make an unreasonable prayer, only 3 days, 2 days. Next week, Monday.
My lord.
My friend is in any case tired.
My lord, here only 3-4 pages affidavit, my lord.
No,
That
it's
is
not-
the only
it's-
affidavit filed by my lord.
Not on that matter, I have some personal difficulties after the motion matter.
My lord, in that case, my lord, matter will be listed tomorrow, my lord. Tomorrow, my lord,
Monday,
because there is urgency, my lord, this is the fixed matter. On the last occasion, my lord, we made an NDVO for my lord, disposal of the matter, my lord. However, the matter has been fixed today. So therefore, my lord, only the issue is very small, my lord.
We'll have it on Monday, okay?
Monday.
As prayed for by Mr. Deep Pagani, learned counsel for the petitioner. List the matter again on Monday.
The interim order.
Why is it listed for orders?
Should have been for admission, for admission here.
For admission hearing?
Evening.
Monday on for admission hearing, give the date. Interim order passed earlier shall continue till then. Yes,
My lord, the pleasure.
May I please, Lordship?
yes.
I'd like to mention one unlisted petition.
Unlisted,
Tender, yeah, tender matter.
then the matter.
Lordship.
What is the urgency? When?
At 2, Lordship.
At 2.
Yes, Lordship.
Why, what is the urgency?
Lordship, actually, this writ petition, I was allowed to submit my bid. However, they have accepted my bid also, but
We have
they-
it tomorrow then?
tomorrow. Lordship.
Tomorrow.
Okay. God bless you.
Yes,
May I proceed?
yes.
I like to mention item number 9 and 15.
Item 9.
9 and 15.
No, I mentioned one at a time. Item 9.
9
what-
and 15. 1-5. Learned counsel is out of the session.
Who is out of station?
Teeth about.
Petitioner.
Yeah,
Okay, when do you want it?
after we,
Mr. T. Tapak, learned counsel for the petitioners, is reported to be out of station. Pushed upon a mention made on his behalf, matter stands adjourned for a week.
I'm for the respondents. But no, you have not yet informed me.
You have objection?
Yes,
Which respondent? You are for the
state respondent.
state respondents.
Anyway,
Hmm.
if Mr. Tapa is not there, then I have
Okay.
no issue.
15 also you're there?
yeah,
Same order in item 50. Make the habit of informing the other side. All right. You don't take them by surprise like that. You should always inform that I'm going to mention. And even if he does not agree, you can ask the court, although they doesn't agree, but I want to mention.
yes,
like
sir, Kamduk, sir, the Kamduk, consent from the Kamduk, sir.
Sorry?
The Kamduk, sir,
Ah,
item number 9,
uh-huh.
consent from the Kamduk, sir.
The Kamduk is for what?
Uh,
Is for the one respondent, isn't it?
Yes,
But then land management is also there.
yes.
yeah,
RWT is also there. So that is why. You should consider all the parties.
Okay.
I'm going to mention. So please accommodate like that. Even if they don't accommodate, you can still ask the court, but you must inform them. Okay?
okay, sir.
All right. 9 and 15 after 1 week. Yes,
Lordship, I like to mention item number 1 and 2.
1 and 2.
Yes.
So what do you want?
This matter may be adjourned for today and
Why?
leave after 3 weeks. Leading counsel, Mr. L. Perme is having some personal difficulty.
Who? Mr. Perme?
Yes,
Why? He was here yesterday. Have you informed the other side?
yes.
Okay, Mr. L. Perme, learned counsel for the petitioner, is reported to have some personal difficulties
My
today.
lord, may on behalf of respondent number 2, my lord.
Yes.
And
You have objection?
No, no, my lord. But my
Okay.
appearance, my lord, that may be recorded, my lord.
All right. What is your good name?
T. Kamchi,
Mr. T. Kamji, learned counsel for respondent number 2,
respondent number 2.
has no objection to the prayer.
And
Thank
I'm
you.
petitioner, my lord, in the item number 2, my lord.
Okay, cancel the order. Please rewrite again. Mr. L. Perme, learned counsel for the petitioner in WPC number 349 of 2020 is reported to have some personal difficulties today. To stop on a mention made on his behalf. No, a mention has been made on his behalf that the matter be adjourned for
3 weeks.
3 weeks. To stop. Mr.
T. Kamchi,
T.
yes,
T for Tripura.
yes, my lord.
T. Gamchi, learned counsel for the petitioner in WPC number 292 of 2020, which is tagged along with WPC number 349 of 2020, has no objection to the prayer. Next paragraph. In view of above, matter stands adjourned for 2 weeks.
And lordship, item number
Much-
12 and 13. This matter may be also leased after 3 weeks.
12 and 13.
Yes,
When?
3 weeks, after 3 weeks.
Okay. Have you informed the other side
Yes,
on the prayer made on behalf of Mr. L. Perme, learned counsel for the petitioners? Matter stands and not objected to by the other side. Matter stands adjourned for 3 weeks.
Mayor, my lord.
Yes,
I'd like to mention item number 16.
yes.
The leading counsel for the petitioner is out of station.
Who?
El Kurdu.
Why is it listed today for orders?
Pardon?
Okay, what do you want?
Adjournment. Yes, 16. And I'm appearing on behalf of respondent number 5.
You have objection?
No, my lord, then for a week, my lord.
Adjourned for 1 week?
1 week, my lord.
Okay, as paid for by the learned counsel for the petitioner and not objected to by the other side. Matter stands adjourned for a week. Yes. 1 week.
1 week, my lord. All right.
Malad, I pray that item number, Malad, 17.
Yes.
Malad, this matter may be fixed on Malad.
When?
12, Malad.
Huh?
12 September, Malad.
12.
Malad.
Have you informed the other side?
Malad, in fact, the other party is not reached yet. So therefore, Malad, I'll inform about the telephone. In fact, he was asking me the matter which
Okay, Mr. M. Kato, learned counsel for the petitioner submits that as he has some personal difficulties today, matter may be adjourned for a week.
Malad, let us say
Or maybe matter may be taken up on 12th of September.
12th of September, Malad.
To stop, he submits that he'll inform the counsel for the opposite parties. To stop, in view of above, list the matter on 12th September
Malad.
for hearing.
Deeply appreciated.
Yes. Yes.
Let's say if on instruction of my client, I may be allowed to withdraw item number 8, Lord.
Well, you have got the relief.
No, Lord. Almost matter become infraction. Lord, here the petitioner could not obtain interim order. So in the meantime, this is for the construction work, tender matter. The work is going on, almost it's about to be completed. It is informed by the
Okay.
client.
Mr. K. learned counsel for the petitioner submits that he has instructions to withdraw the writ petition. To stop, in view of above, the writ petition stands dismissed as withdrawn.
Deeply obliged.
Thanks. I plead your lordship.
Yes.
My lord, we have challenged, my lord, the impugned NIT and the subsequent result basically on 4 grounds, my lord. Number one, non-publication of the NIT in the newspaper, my lord. It is also, my lord, mandated as well as it has been the convention, my lord, that even the same department, my lord, all along they have been publishing such NIT in the newspaper, my lord, except in the instant one, my lord. They have not published. And that too, my lord, when there is a standing government notification, my lord, whereby it is stated that, clearly stated that tender should be in a normal mode, my lord.
Where is that? Where is that?
My lord.
Standing government notification.
Yes, my lord.
Page.
My lord. Come. My lord, it is a page 193, my lord. This notification supersedes all the earlier notification, my lord. This supersedes all the earlier notification.
Page number.
Page 193.
It can't be 193.
Of the, my lord.
Okay, it's
item
the
20.
manual.
Yeah. Of item 20, my lord.
We are in item 19. Okay. You are for the item 20.
Sorry, my lord. Item
20, is it?
Yes, ma'am.
376.
Yes, ma'am. Page 193, my lord. 193. Item 20. Of item 20.
You are Mr. N. Pada.
Yes, ma'am.
Okay.
May I read the notification, my lord?
Mr. Potom.
Yes.
Yeah, Mr. Potom.
Yeah.
Take your seat. You relax. We'll hear you also. Okay. Let Mr. Pada complete his part. 193.
So, my lord, till the month of May, my lord, this year, the same PWD, my lord, is the PWD. They used to.
Just a minute. Let us see this 193. What is this?
Yes.
This is a notification up to 2020. Please read.
In supersession of earlier government notification number so dated 11 October 2017, dated 17 July 2018, and 24 September 2019, mandating procurement of goods and services of all government departments, directorates, associate office, societies, boards, PSUs, corporations, government e-market, except as respect in things done or committed to be done before such supersession. The governor of Arunachal Pradesh is pleased to order that in view of the government policy of vocal for local and Atmanirbhar Bharat to encourage local entrepreneurs, the first priority on any procurement of goods and services shall be done locally through normal tender, my lord. Meaning there, my lord, publishing in newspaper, my lord. And further that only when items are not available locally through normal tender, the procurement shall be done through government e-market. This notification shall come into force with immediate effect, my lord. So prior to this, my lord, in the 2019, the publishing in newspaper was done away with, my lord. But there also, my lord, not fully, partially it was done away with, my lord. So the on the basis of this notification, my lord, all the department, including the instant one, my lord, the state PWD, they have been publishing all such NIT in widely read newspaper, my lord. I have annexed, my lord, in my additional affidavit, my lord. In one instant at Taliha also they published, my lord. But for the first time, they have in the instant one they have not published in the newspaper, my lord. And that is the first ground of our challenge, my lord. And the second ground of our challenge, my lord, is that since this NIT was not brought to public domain, my lord, only in the 11th hour, only one firm from the state, he could manage to participate, my lord. But later on, it was observed, my lord, that a very strange clause, my lord, was inserted to indirectly oust the other intending bidders and to accommodate the, my lord, respondent number 4 and 5, my lord. Their intention is clear, my lord.
What is that?
My lord, it is page 45 of my writ petition, my lord. May I read, my lord, the clause 16.1, subclause D, my lord, the down below. The original instrument in any form as above should be deposited in the office of the executive engineer, Passigat PW division, at least 1 day before the last date of online bid submission, my lord. So
You're reading from page?
page 45, my lord. The convention, my lord, is there.
No, just a minute. I've not got page 45, so you should make sure that I read we read it together.
Yeah.
45 shows something else in my copy. These are all what? This is from the IFB,
Yes, my lord.
paragraph 16.
Clause 16.1, subclause D, my lord, down below. Subclause D of clause 16.1.
Correct. So you mentioned the issue that you did not mention the subclause D.
Yeah.
16.1D.
Yes.
Correct?
Yes, my lord.
What's so strange about this?
Yes. So,
Hmm?
yes, my lord.
What's so unusual about this?
This, my lord, instead of, my lord, at least 1 day before last date of online bid submission, it should have been the last time and date of submission, my lord. They have been doing all along in other NIT like that, my lord. This was done because 10th July, my lord, 10th of July, my lord, was the date for submission of online bid, my lord. So when the date for submission of online bid itself was 10th July, my lord, no one could submit the hard copy before that, my lord. And on the top of that, my lord, last date of submission of bid was on 10th July, and 9th, my lord, was a Sunday. 9th was a Sunday, and 8th was Saturday, my lord.
Last date was which date?
Sorry, my lord.
Last date was
10th July, my lord.
10 July.
Yes, man. That was a Monday, man. 10th July.
Oh.
10th July.
1 day before the last date.
Pardon, my lord.
10 July was
For the date for submission of online bid, man.
Monday.
Online submission of online bid. So, according to this subclause D, my lord.
So what is wrong with this?
This was my because
What is wrong with this?
they have mentioned, my lord, the hard copy should be submitted at least 1 day before the last day of online bid submission, my lord. So no one could submit because, my lord, 9th was a Sunday and 8th was Saturday. So at least it should have been mentioned in any working days, my lord. It is clear, my lord. It was a holiday, my lord, non-working day, my lord. And the convention has been that although last date of submission is mentioned, my lord, it is usually on 3 working days, my lord. At least 3, the bidders should be afforded opportunity, my lord, at least before 3 working days, my lord. But here in the instant case, my lord, it was a holiday, my lord.
Okay.
Saturday and Sunday, my lord. That is the second ground, my lord.
All right.
And third ground, my lord,
Yes.
that on being agreed with this, my lord, after they came to know that some eligible contractors, my lord, they filed a complaint before the appropriate authority, my lord, and the PWD, my lord, they forwarded the matter, my lord, to the user agency, that is the Department of Medical, my lord. And on the basis of the complaint, my lord, the medical Department of Health, my lord, they directed the PWD department to suspend the NIT for some time and to file a reply, my lord, against
Page.
page 139, my lord. Page 139. May I read, my lord? 139.
Yes.
This was addressed to the Chief Engineer Central Zone, PWD Passigat, my lord. subject suspension of tender number so and so dated 22/6/23 for the project upgradation of Bakin Perpin General Hospital, Pasigat to 300 bedded hospital in Eastern District AP in view of the complaint filed by all Arunachal Registered Contractors Association, my lord. So, taking cognizance of the complaint, my lord, they have addressed the PWD. Dear sir, I am directed to invite a reference to the complaint received from all Arunachal Registered Contractors Association against e-tender number so and so dated 22/6/2023 for the project upgradation of Bakin Pertin General Hospital, Pasigat to 300 bedded hospital in Eastern District AP. A copy whereof is enclosed for perusal. And to inform you that the competent authority has decided to suspend the tendering process pending disposal of the complaint, my lord. You are therefore requested to file pairwise replies to the complaint and suspend the tendering process immediately till further notice from this office. The replies may be furnished to the undersigned as early as possible, ma'am. So, in spite of the receipt of this, my lord, notice, they proceeded with the tender process, my lord, because health department is the user department, my lord. They also found some discrepancy, my lord, for non-compliance of Indian public health guidelines, my lord. So they also directed the PWD to verify, my lord, the veracity of the complaint, my lord. And in spite of receipt of this suspension order, my lord, they went ahead, the PWD department. So if they wait for some time, heaven will not have fallen, my lord. So their intention is clear, my lord. This is the third ground of challenge, my lord. And the fourth ground, my lord, there is clear violation of Article 14 of the Constitution, my lord. Normally, my lord, the High Court doesn't interfere on the matter of judicial review, my lord. But there is, if there is clear arbitrary and mala fide, my lord, the court can interfere, my lord. In this case, my lord, there is clear arbitrary and mala fide, my lord. Because, my lord, this the place where this project is proposed, my lord, that is a Pasigat, the oldest town in Arunachal, my lord. So that is a lifeline of the whole of the eastern part of the Arunachal Pradesh, my lord. So if this is materialized, my lord, even some parts of neighboring Assam will be benefited, my lord. So that is why the quality also should be maintained. There should be transparency, my lord. Transparency in plotting of tender even, my lord. So
How do you say Article 14 is violated?
yes, because, my lord, all other eligible intending bidders, they were not afforded opportunity to participate, my lord, in the tender. Because everything was done in a hush manner, my lord.
So that is covered by your first point, isn't it?
Yes, my lord.
Your
My
first point is that the priority is to be given for publication of the tender
Yes.
as widely as possible.
My lord, the only contention, my lord, on the part of the department is that website portal address was given, my lord. Even to locate the website portal address, my lord, that has to be publicized, my lord. Where from the intending bidders will get the website address, my lord, unless it is made public, my lord. So they have tactfully done, my lord, with a malafide intention, my lord. And, my lord, every department, my lord, of a state is a welfare state, my lord. They cannot be biased and partial and one-sided, my lord. As far as possible, my lord, maximum participation should be ensured, my lord, to get a quality, my lord, infrastructure, my lord.
Yes. Those are the 3 points.
My lord,
You finished?
yeah, I would like your lordship to see, kindly see, my lord, page 10 of my, my lord, additional affidavit, my lord. Till recently, in the month of November, May, my lord, till month of May, my lord, they used to publish tender in all widely read newspaper, my lord, inclusive of the one, the Arunachal Times, my lord, which is the most popular daily of the state, my lord.
Where is your additional affidavit?
Page 10, my lord.
No, the additional affidavit itself. Have you filed it?
Yeah. Or, yes, we have filed it
When did you file? It is not available here.
last Friday. Or my lord, the same thing is my lord, has been annexed in the item number 19, my lord.
But who has permitted you to file an additional affidavit? Did you take the permission of the court to file additional affidavit?
No, my lord.
Then one fine morning you wake up and you find that I need to file one more affidavit. You come and file. How can that be?
Anyway, my lord, my lord,
You should take permission. Say, there are some developments. I may be permitted to bring it on record by way of additional affidavit. That is the normal course.
right, my lord. I'm sorry for that. Even my lord, without relying on additional affidavit, my lord, the same documents has been annexed in the item 19 also, my lord, whereby the same department, my lord, has mentioned as last date and time of submission of bid. It should have been last date and time of submission, my lord. So they have tactfully inserted instead the original documents should be submitted at least one day before the last date of submission of online bid, my lord, which is impossible, my lord. Rather.
So why do you have to wait till the last date? The tender says last date, before the last date you submit.
Yeah,
You can submit before 5 days before last date also.
No,
Is there any bar
Yes.
that you have to submit only 1 day before?
my lord.
Before that, they will not accept. Is it like that?
Yes. No, my lord, because
Then-
since it was not brought to public domain, my lord, and I think it's a one.
See,
from-
since you are being technical, that's why I'm also asking you a technical question. 1 day before the last date.
Yes.
1 day before the last date, does it imply that it has to be only on that date
Yes, my lord.
and not any other date?
Since my lord, the NIT itself was not brought to public domain, man. On the
No,
last
that is a different thing. That is a different thing.
Yeah.
First point is that NIT is not in the public domain. So in some website they are published, we don't know. Second thing is that the original documents have to be submitted 1 day before. That's the second point, correct? So you came to know when? After the last date, isn't it?
yes, my lord.
So it does not matter. You have come to know only after the last date.
Yes,
It is not that you have come to know just 2 days or 1 day before the last date.
yes,
The day being Saturday, Sunday, you could not act.
yes,
It is not your case.
yes,
You came to know only after the tender was closed.
yes, yes, my lord.
So what is surprising about that? They must have miscalculated, isn't it? It can happen.
So, one in the name and ages of my lord, Kenger Construction, that was the sole firm who could participate on the 11th hour that also. So his bid has been rejected, my lord, on the ground for non-compliance of non-fulfillment of clause 16.1.
Which party?
One Kenger Construction, my lord.
Is it before the court?
No, my lord. His bid was not even open, my lord, because for non-fulfillment of clause 16.1, my lord, D.
He's not before the court, so that's not our concern.
Yeah.
Isn't it?
So, my lord,
Supposing he comes here with those grievances, then we look into it. If he's not here, why should we go and examine each and every allegation that this has happened, that has happened? Let us confine ourselves to your grievance.
Yeah.
Okay.
Yes.
So your grievance are basically threefold,
yes,
isn't it?
yes, ma'am.
No publicity.
Yes.
In terms of the notification of 2020, then clause 16(1)(d),
Yes.
which says 1 day before. This is also, which is very unusual
Yeah.
in this particular tender process. Number 3 is the
Suspension order, non-compliance.
director. The user department has also even agreed that there's some complaint. So take care of the complaint first, then you go ahead with the tendering process. But
Yes.
instead of that, they went ahead. And finally, there's violation of Article 14 because of the eligible bidders who had wished to participate have been deprived of participation.
Yeah.
That's it. Any authority you want to rely upon?
Yeah.
Any judgment?
Yes, my lord. I have placed reliance on two judgment of this court, my lord.
Did you rely upon this NG projects?
Yes, my lord. Yeah.
Who has relied upon NG projects?
My lord, may I read the operative portion, my lord,
Hmm?
of the judgment?
Where is the judgment?
That is 2015 GLT, 2018 2 GLT, my lord. In the matter of, my lord, ML Enterprises versus the state of AP and others, my lord.
Have you supplied the judgment? This is from the High Court. Our library, High Court library. Okay. What is the citation?
Sir, it is para 46 and 47, my lord. May I read the para 46, my lord?
What is the name of the parties?
It is ML Enterprises versus the state of AP and others.
Okay, and you want to read paragraph number?
Paragraph 46, ma'am. May I read, ma'am?
Just a minute. Yes.
My lord, with regard to the distribution of state largesse or government contracts, it is well settled that a statutory body and instrumentalist of the state should act fairly by making it open for all eligible to submit their offers, and the awarding of contract without inviting tender cannot be said to be fair, and any such contract is liable to be quashed. Contracts by the state, its corporations, instrumentalities, and agencies must be normally granted through public auction or public tender by inviting tenders from eligible persons, and the notification of the public auction or inviting tenders should be advertised in well-known dailies having wide circulation in the locality with all relevant details such as date, time, place of auction, subject matter of auction, technical specifications, estimated cost, earnest money deposit, etc. The award of the government contracts through public auction or public tender is to ensure transparency in the public procurement, to maximize economy and efficiency in government procurement, to promote healthy competition amongst the tenderers, to provide for fair and equitable treatment of all tenderers, and to eliminate irregularities, interference, and corrupt practices by the authorities concerned. This is required by Article 14 of the Constitution, and any violation of this process, any government contract awarded by statutory bodies and instrumentalities of the state are liable to be set aside and quashed. And paragraph 47, for the reasons above, the state respondents are directed to stop the work of improvement and construction of road from Pakam Tinale to Jirin Tri-Junction and Pakam to PMGSY road to Timro area at Arlo being carried out by the private respondent number 8 and 9. The state respondents are also directed not to allow the said work of the road in question under the special plan assistance schemes without issuing public plotting notice inviting tender, and not to release such grants and state largest sanction for the work of improvement and construction of the said road in question to any firm or person as the case may be, without due procedure established by law. With the aforesaid observation and direction, this petition stands allowed, my lord. So here in this case, my lord, even the work was started, my lord, but on interference of this court, my lord, the department had to plot tender, my lord, to ensure maximum participation, my lord. And my lord, secondly, my lord, I have placed reliance on, my lord, Ramana Dayaram Shetty versus the International Airport Authority of India, my lord, 1979, 3 SCC, my lord, para 14.
1979,
3 HCC,
3 SCC.
page, paragraph 14, my lord.
No, page number
Page number 489.
489. Paragraph,
489.
paragraph,
489.
paragraph.
Oh, paragraph 14, man. This is-
Hmm. Yes.
May I read, man? It
Yes.
is now well settled as a result of the decision of this court in P. Rapa versus State of Tamil Nadu and Maneka Gandhi
Just a minute,
versus
just a
Union of
minute, just a
India.
minute. You said paragraph 14,
Yes,
1-4,
yes.
but it's different here from what you're reading. How does it start? A corporation.
Yes, it is now well settled, my lord. Maybe, my lord, this has been printed, my lord. The paragraph number is different, my lord. My lord, may kindly see the
What is
page.
this?
This is the one printed, my lord.
You printed from the website.
Yes, my
What, Indian Kanun or what?
yes.
Huh? There is no paragraph number.
Yes, my lord. But
So
it is at page
give him
25,
back,
my lord.
give him back, give him back. There is no paragraph number. How do we? It is well settled, you said, isn't it?
Yes, my lord.
Is it towards the end of the judgment somewhere?
No, in the middle part, my lord.
In the middle part?
Yes.
Problem is that we should have
1917.
should have found out from the SCC or AR or whatever. Anyway, you read what you want to read. Read.
It is now well settled as a result of the decision of this court in P. Rapa versus State of Tamil Nadu and Maneka Gandhi versus Union of India that Article 14 strikes at arbitrariness in state action and ensures fairness and equality of treatment. It requires that state action must not be arbitrary, but must be based on some rational and relevant principle, which is non-discriminatory. It must not be guided by any extraneous or irrelevant considerations, because that would be denial of equality. The principle of reasonableness and rationality, which is legally as well as philosophically an essential element of quality or non-arbitrariness, is protected by Article 14, and it must characterize every state action, whether it be under authority of law or in exercise of executive power without making of law. The state cannot therefore act arbitrarily in entering into relationship, contractual or otherwise, with a third party, but its action must conform to some standard or norm which is rational and non-discriminatory. So here in the instant case, my lord, their attitude.
It is paragraph 21 here,
Okay.
but it does not start with it starts with some other sentence. Yes.
Sorry, since my lord, the book was not available. So my lord.
Yes, I found it anyway.
Uh-huh.
So
my prayer, my lord, would be that this impugn NIT be, my lord, set aside, and all the eligible intending bidders, my lord, may be afforded opportunity by publishing it widely, my lord. And the respondent number 4 and 5 also may be allowed to participate, my lord. Because, my lord, this involves a huge public interest, my lord. Once it should be made in a very transparent manner, my lord, because in a remote state like Arunachal, my lord, hardly there is any medical college or good hospital, my lord, because this covers 7 districts, my lord. And if Assam is included 8 districts, my lord, this is the lifeline of 8 districts, my lord. There is, we have no intention to stall or stop any such project, my lord. But our grievance is that the best qualified firms should be allowed to carry out the infrastructure, my lord. And because once it is constructed, my lord, it is very hard, my lord, to, in the state of Arunachal project, to initiate such project, my lord. Other than these streams, my lord, this will be the only 2nd largest hospital in the state, my lord. That is why we are pleading that a huge public interest is also involved in this case, my lord. And the action of the respondent authority has been quite discriminatory, my lord. And this is the, my lord, first of its kind in the matter of tender, my lord. This has been done, my lord. They have been maintaining all along the transparency, my lord. But for the reason best known to them, my lord, they have done this in a hush manner, my lord, without any knowledge, and the same being, my lord, brought to public domain, my lord. So my prayer basically, my lord, would be that let the fresh tender be floated, my lord, ensuring all the eligible participants by publishing it widely in a widely read newspaper, my lord.
Okay,
Publishing, thank you.
let's hear Mr. Potam. Yes, Mr. Potam. Your writ petition is 403, isn't it?
Yes. Item number 19.
Okay. Yes, please start.
My lord, apart from yesterday's submission, in my petition, in plain page number 18, 28, my lord, I have given the definition of open tendering. My lord, this tender was an open tender. My lord. It was a global tender that required by participants. My lord, open tendering is the process of inviting bids for project goods services in an open and transparent manner. The details of the project or requirements are publicly advertised, and any entity meeting the required qualification can submit a bid. The open tendering process is designed to promote fair competition and level playing field for all bidders, larger or small. It allows for greater scrutiny of bids by interested parties, which can help to widen out corruption and collusion. My lord, this board has also particularly the newspaper was chosen with oblique intention to stop compliances, my lord. And any government tender notice be published in widely circulated newspaper. This was the contention made by the petitioner, and by hearing this contention, our learned and honorable judges, Justice Merita, observed that in view of the aforesaid facts and circumstances, there is one conclusion of this arrival, namely that the impune settlement of the suit fisheries institution have been done without following due process of law. This court of the view that the requirement of maintaining fairness and transparency in matter of distribution of state learning has been totally done away with in the present case, whereby beneficiaries appear to have been chosen without there being any condition. It is needless to state that first process which may be initiated is to be strictly in accordance with law. According to this judgment, my lord, even the newspaper is published in NIT published in newspaper, it should be in widely separated one.
That is in which paragraph of this judgment?
Judgment.
Paragraph 13, I think. Paragraph 13. Okay, I got it. Don't bother.
And secondly, in my lord, in the SPN Enterprises versus State of Nagaland and others, while with petition number 63 of 2019, this Honorable High Court also observed that, my lord. Keeping in mind the fact that contract was awarded without any publication of NIT in any newspaper or in mass media, which is against the public interest, and the interest of the public, etc., issuance of the work order is to be arbitrary. Accordingly, the work order that is 6/3/2018 issued to the respondent number is hereby satisfied. To further action should be taken in pursuant to the NIT. However, the work already done by the respondent number 7 is not interfered with by this court, as the bill of the same has apparently already been paid, as is alleged by the respondent counsel. However, the state respondent has caused the press exercise to be made by taking the measurement of the actual work done by the respondent number 7. And recording the same in the measurement book of the PWD department, PWD period of 3 weeks from the date of receiving of copy of this order. Therefore, the remaining portion of work to be done, the state respondents have published a press advertisement and give wide publicity in the same in the non-newspaper and also by utilizing other means. So, advance calling for bids from eligible contestants. The said advertisement will be issued within a period of 6 weeks from the date of receipt of a copy of this order. Selection of a successful bidder shall be made not later than 2 months from today, as applicable rule, guideline and procedure, as the extent of the extension state respondent is that the contract of which to be completed urgently. My lord, by virtue of above judgment, the work already awarded and bill or paid has also been set aside in request by this honorable court. In the instant case, the private respondent has nothing to lose, since the no work has been awarded to them and the work has not been started yet, my lord. So the private respondent has nothing to incur losses either, my lord. So that this NIT is liable to be cancelled and set aside, my lord.
That state of Nagaland and others which you referred to, that is SPN Enterprise, is it?
Yes.
Do you have a copy of the judgment?
Yes, my lord. This Assam PW department, they floated the newspaper NIT without floating newspaper, my lord. They just copy and paste the notice board in this case, my lord.
Well, in SPN Enterprise.
Yes, it's been enterprise. But my lord, by creating this impunity, nobody is going to encourage.
What is the relevant paragraph? Yes.
Last second test. Paragraph 23 from 23 to 24. 23 and 24. 23 last line, keeping in mind fourth line of the paragraph 23.
Hmm. It also refers to one case. Ikyao Lotha,
Yes,
correct?
yes.
Ikyao Lotha. Okay, just a minute, huh? Para 15. Just a minute. In this case of SPN Enterprise, the only publication was, there was no publication, but it was put in the notice board.
Yeah, no newspaper publication.
No newspaper publication, but it was pasted only in the notice board.
No newspaper, completely, it was no.
Understood, there is no newspaper,
Yes,
but that notification was pasted in the notice board.
yes,
So that was found to be not sufficient
yes,
by the judge.
yes.
Learned single
It
judge.
should be
Hmm.
published in widely circulating newspaper.
Okay, got it.
My lord, as I have already stated, nobody is going to incur any losses. If fresh energy is directed, it will be prisoners to not, my lord. Rather, it will provide equal opportunity and value for money, my lord. In this energy, according to technical procedure, the respondent report has offered 115 crores, my lord. Estimated cost put up for was the 99.03 crores. They have offered 15 crores, 97 lakhs more. As per the guidelines, price escalation should not be more than 5% or below more, not below 5%. But whereas it is more than 15%, my lord. This is one thing need to be pondered upon by the department. Who gonna pay this 15 crore 97 lakhs? This whether this DME, Director of Medical Education, is going to pay this extra 15 crore 97 crores, or this executing agency is going to pay. My lord, where I am referring is that if opportunity were being provided, I could offer value for money. I could offer, I can complete this project in 199 crores, my lord. Where then this government, the executing department wanted to give the respondent for in 115 for 97 crores. My lord, however, I would like to reference Article 246 of the Indian Constitution, where it is written that in these 3 and these 4 of the 7th schedule, the state can amend this laws in this subject. However, if there is any accidental encroachment of the central government and the Indian Parliament and the state legislature, the doctrine of fifth and substance will be determined. My lord, where I am referring is that CPWD manual and SOP are not connected by the Parliament of India. This is just guideline and SOP. So the state of Arunachal Pradesh has right to regulate this law, my lord. Henceforth, the Chief Secretary of the state through issue notification to restore the mandatory publication of NAP on 98 2020. And the Department of IPR is to guideline to regulate the CPW making SOP EPR when it comes to the newspaper publication on 30/1/2018. This could not be overlooked by the Honorable Court, my lord, because if newspaper publications of the NAT is done well, my lord, this will overrule the judgment pronounced by this court, and it will directly affect the existence of Department of Information and Public Relations Government of Arunachal Pradesh. As the sole objective of establishment of this state department was to regulate and government advertising, including NATs and ENAT within the state of Arunachal Pradesh, my lord. And this Department of Information and Public Relations has right to regulate the CPW manual, because it is not a law enacted by the Parliament of India. This is just the guideline. And my lord, it will strike down the notification dated 30/01/2018 issued by Department of Detention and Public Relations, and it will strike down the notification of Chief Secretary Government of Arunachal Pradesh dated 19/8/2020, where the mandatory newspaper publication was restored, my lord. And it will directly confronted with the Article 14 of the Indian Constitution, because the right equality before law and equal opportunity was violated in this NIT, my lord. Further, my lord, it will set a negative trend, my lord, because the department will tend to research more practices in days to come, my lord. They will publish in newspaper, sometimes they will publish in website, and they will say, no, we have published in newspaper. And sometimes they will say, no, we have published in website, web portal. And this will confuse the eligible bidders, they will and other contractors, my lord. And it will trigger more litigation against the department, my lord. That is where we need a clear order that whether the NIT should be published in newspaper or not. And it has been doing since the inception of the PWD, my lord. They have been publishing each and every NIT, PNIT through newspaper publication, but single NIT was not, my lord. That is the way I raised the objection, my lord.
Yes.
So, my lord, I pray this on the court to quest and set aside this NIT and press NIT be plotted to by according all eligible bidders to participate for the sake of state government, my lord. That the value for money will be provided. I can complete this project in 100 crores. Why should we waste more than 115, 16 another extra money?
How much was quoted by the tenderer? L1,
L1 115 crores, L2 113 crores, whereas estimated cost for tender was 99 crores, 3 lakhs. There is 15 crores, 97 next price escalation.
No, L1 is 150, L2 is how much?
130 crores more.
113. Okay. Now, what is the position as of now? The technical is open, financial bid is also open,
Yes,
and L1, L2 has been named.
yes,
But the actual award has not been given till now, isn't it? There's an interim order from this court,
yes,
status quo.
yeah,
That's all.
yeah.
Anyone has disturbed you? No one, na? So I hope that you don't disturb anyone.
Okay.
If you want to make a reply, you just note it down. You'll get your chance again. All right. Let us hear the other side now. Mr. Kapin?
No. Lordship, Lordship express reduce the Lordship request as to whether Lordship it has been duly uploaded in the portal or not.
Yes.
In this year, Lordship, my first submission is that request is available with me, Lordship. Approval of the Lordship chief engineer has been taken, Lordship.
Approval of the
Chief engineer, approving authority, NIT, to be uploaded in the e-portal, Lordship.
Okay.
Our official e-portal is there, Lordship.
Okay.
Then approval is there, Lordship. That is done. And so for uploading in the portal is concerned, Lordship. That is not disputed by the petition. That is not issue here, Lordship. Question is lordship whether it's sufficient or not. That is the issue. What they are raising is that along with the lordship that publication in the e-port.
Correct, Mr. Tapin, before you continue, reason why we asked for the record is that you say that it was uploaded in the portal. Those are your contentions. So we would like to see whether it was actually uploaded in the portal and what was the procedure adopted. That is what.
Oh, no. That is
Because you also are not saying that you are advertised in the newspaper.
Oh.
So there's clearly, it's nobody's case.
Yes,
That newspaper also was there and portal thing was there. They say there is no newspaper. You say there's only portal, which is sufficient. So that is why whether that portal, which is said to be sufficient, was actually, like what was the process, how it was put up in the portal. That is what we would like to know.
Lordship, this particular portal is being generated by lordship.
Just consider the court to be have no knowledge about all these technicalities.
Lordship.
So please explain from.
Lordship, here lordship, National Informative Center, that is NIC lordship, who control and regulate the lordship this very portal. Under this lordship, so many portals of different lordship, department lordship is being lordship permitted and is created lordship.
Portal means that is exclusively for one particular department.
For one particular department.
I see.
Then lordship, what happened lordship? Since all the portal comes under the NIC lordship, now when it's created lordship, any information lordship uploaded in that particular portal lordship, that is got interlinked with the other lordship portal lordship. You can access lordship. Once we enter into this NIC lordship, this lordship page lordship, we can lordship access the NIT floated in of the Arunachal Pradesh, Assam, and all lordship, we can access that. So this is a common lordship platform lordship where this NIC is.
Who can get access to the portal?
Anyone lordship. Anyone.
What is the difference between the portal and the website?
Website and portal is same thing only.
Same thing.
Same thing.
And what is the website? What is the address?
Website is lordship where lordship information is lordship uploaded.
Correct. What is your website address of the PWD?
PW lordship. Our is lordship the arunachaltenders.gov.in.
Huh?
arunachaltenders.gov.in.
Is it there in the
NIT?
Just a minute. Where?
Lordship, can you see this one, Lordship?
You said it's in the tender.
This is also part of the request, Lordship, but I'm just placing it, Lordship.
No, it's not available in the writ petition.
It's available, Lordship. This we have downloaded from the Lordship web page yesterday only. On top, Lordship, right inside, Lordship will find the Lordship date. On top, Lordship, e-procure system, Government of Arunachal Pradesh. The website name is Lordship, arunachaltenders.gov.in, Lordship. So this is the Lordship, the details which was uploaded in this very website. It's the web portal, Lordship. And in read petition itself, Lordship. In NIT itself, this very Lordship web page has been mentioned, Lordship. And we downloaded it from very web page where it was uploaded.
Okay.
So this is how Lordship the tenders is used to be uploaded in the web page. And anyone can access the Lordship, the tenders Lordship. Anyone Lordship.
Okay. See,
one need not to Lordship have any kind of password in all Lordship. Anyone can enter, anyone can
see. E-tendering, all these things are happening. We are in the thing is that in this part of the country, there is irregularity of the power supply website. I mean, the internet connectivity is also off and on. How how acceptable and how safe it will be that you just go for e-tendering by posting the tender documents or publicizing the same in by way of this media? How safe will it be?
Lordship, on this, Lordship,
And if that is good enough, there are various documents here annexed here in the writ petition
Lordship.
as recent as May of this year to show that the PWD is also going ahead with the paper publication. Isn't it? What prevented you from not making the paper publication in this case?
Lordship, since that's the set norms, Lord. On this point, may I, Lordship, submit one thing, Lordship?
Is there any consistency in your stand? That no, since this year or since this month, we have been going only for this e-tendering. We have not gone for any other paper. Those were gone are the days when we started doing, when we published in the newspaper. Is that your stand?
Lordship,
But there seems to be no consistency.
Lordship, here I'll place one thing. Here, Lordship, so far the Lordship, formulations of the norms, Lordship, manner and method how it has to be published, and manner and method, Lordship, how the NIP has to be plotted.
No, if
It's
correct.
within the domain of the authority, Lordship.
Correct.
Now, this Honorable Court has to ensure, Lordship.
You're saying that
whether
you're going by the book. You're saying you're going by the book. CPWD manual is there. Then what is the other one that what is that? Huh? GFR, General Financial Rules. Those basically provide for e-tendering.
E-tendering.
There's an option there for other form also, but e-tendering, it's basically oblique this.
No, sir.
So there's no compulsory thing. You're not compelled to go for paper publication.
No.
If you go by the book, okay, you may be right on that.
Now,
but generally, if you think, see, you're going for such a big tender, almost how many crores? 99 crores.
hello, sir.
Shouldn't you have more, like publicity and people participating?
No, sir.
Where's the harm?
Lordship, therefore, Lordship, at this stage, Lordship, when Lordship technical bid has been opened and financial bid has been opened, there's no allegation, Lordship, that the bidders who have been selected in the financial bid, who have been recommended, Lordship, they are not eligible. There's no whisper, there's no allegation on their part, Lordship. Had there been the allegation, Lordship, the person who is not eligible, Lordship, he has been selected, Lordship. Definitely, Lordship.
That's a different thing.
How public interest will prejudice, Lordship?
No, that's another point. We're on the other point, publicity.
Therefore, Lordship, to my understanding, Lordship, for this Honorable Court, Lordship, this Honorable Court has to be ensured, Lordship, whether we are abide by the formulated norms or not. That has to be seen by this Honorable Court, Lordship. We have formulated certain norms, guidelines is there, Lordship, for publications. We have, whether complied or not, we have abide by that or not, that has to be ensured by this Honorable Court, Lordship. So, but our act of, in addition to what is the requirement, Lordship, if we have done something, Lordship, can that be precedent and basis for Lordship, to go for the legal basis for Lordship to say that, Lordship, since you have made a paper publication in addition to what is required in the rule, so you go for that same. Can that be basis, Lordship?
So what do you say about the notification which was referred to? At page 193 of the other writ petition.
Lordship.
The first priority is to requisition the expertise, materials, the goods and services locally through normal tendering process.
Lordship, I'm coming, Lord.
This was published in the year 2020, 19th of August 2020. If you're saying that you're going by your own instructions.
Lordship, I'm coming to that point. Lordship, 210, Lordship, in this petition, Lordship.
Which one? In
This is
376?
This is 403, Lordship. And page, Lordship,
Page 193. 193.
Page 193.
Yes.
Lordship, this writ petition is 403, Lordship. I am in 403, Lordship.
Is it available in 403 also?
It's available here also, Lordship.
On which page?
218, Lordship. $218.
No, this is slightly different.
No, 219 Lordship. Because 19 is modifying the 18 Lordship.
Yes, 19. That's correct. 219. What do you say about
Just
this?
before coming to page 218, that is 19 August 2020 notification, Lordship. Just I'd like to read here this page 218 first, Lordship.
18, 2018, 218 first.
218 first, Lordship.
Yes.
Consequent upon amendment of general finance rules so and so, in respect of tender advertisement for procurement of goods and services, the need for publishing advertisement in newspaper for procurement of goods and services has been done away with. It may be noted, Lordship, as per the GFR, Lordship. This has now been replaced by a mandatory e-publishing of advertisement on Central Public Procurement Portal. It's so and so website and website of Department, Lordship. Therefore, all the department offices of the government of Arunachal Pradesh are directed to strictly adhere to the provisions contained in GFR 2017 regarding publications of advertisement for procurement of works, goods and services, and publish the tender through government e-procurement system of NIC, GNP so and so. The three option has been given to the department, Lordship, for our state, Lordship, 1, 2, and 3, Lordship. We have opted for the second one, Lordship. In case it's felt that advertisement is necessary to publish in the newspaper so and so, then Lordship, permission has to be obtained, Lordship. Now, kindly, rather here, Lordship, for paper publication, permission has to be taken, Lordship. But general rule is there, Lordship, to go for e-tender. Then kindly come to page next, which my friend for the petitioner is emphasizing, Lordship.
Yes.
Next page, Lordship. In supersession of earlier government notifications so and so, the procurement of goods and services, all the government so and so, except as respect things done or committed to be done before the supersession. The government of Arunachal Pradesh is pleased to order that in view of government policy of local for vocal and Atma Nirbhar Bharat to encourage local entrepreneurs, the first priority on any procurement of goods and services shall be done locally through normal tender, and further that only when when items are not available locally through normal tender, the procurement shall be done through the government is so and so and so. So here it says, Lordship, if it's available in the locally if it's available, Lordship, then under the government policy of local for vocal, Lordship, we must opt for that, Lordship. And if that's not available, then Lordship, we can go for the e-tendering, Lordship. Now coming to the present, Lordship, NIT, Lordship. Kindly come to the Lordship. This is the main NIT, Lordship.
Just before you go to the other aspect, the 2019 notification says that henceforth the paper notification is done away with. Now, if it's required, you have to take permission.
No.
But then the 2020 notification now in supersession says that because of this government policy of vocal for local,
No.
it has to be locally.
Locally.
If it's not available, then you can go for the.
Correct. That's the Lordship.
So now it's permissible, isn't it? It's not that it's total ban that you should not publish.
Yes, it's
And
permissible.
you take permission before publishing. That is not there anymore.
Lordship. Now, kindly come to this NIT, 22nd 6, 2023, Lordship.
Okay.
SBD has been annexed, Lordship, but this NIT has not been annexed, Lordship.
This NIT is not available in the writ petition or what?
It's not annexed. It's not annexed. But IFB is, Lordship, annexed, which is the part of the SBD, Lordship.
Then what is this one, page 48?
This is IFB, Lordship. page 51 lawsuit.
No, 48. No,
Uh,
before that, it's 47. No, this is registration. 48.
Lawsuit.
Turnkey mode, 2-bit system.
Lawsuit. Turkey mode 2-bit system.
IFB.
Lawsuit.
What is this? This is approval.
This is lawsuit.
This is approval.
This is the yes lawsuit. Approval.
Now,
And
where do we get this document? Where should it be placed?
lawsuit. This is the NIT lawsuit which was uploaded lawsuit.
Okay.
And this page 48 onwards also lawsuit. SBD was also uploaded, which was made available for downloading after 2 days from the date of uploading this NIT law.
First, it is NIT, then
NIT.
it's followed by this page 48.
Correct, correct,
Okay.
correct. If lawsuit see that this NIT lawsuit,
Hmm.
the adjudicate engineer prosecute division PW prosecute on behalf of government invites online tender. Turnkey mode lawsuit. Turnkey mode means lawsuit. This is lawsuit, EPC, tender lawsuit, engineering, procurement, and construction lawsuit. This is a special lawsuit tender. Where lawsuit, the designing right from the designing, that's the preparations of the designing of the building.
Hmm.
Construction, all has to be done by the lawsuit, the bidder himself. Requirement will be provided by the department lawsuit. And all thing has to be done by the, entire thing has to be done by the bidder. This is specialized work lawsuit. So that may be noted lawsuit, very important lawsuit. Now I'm providing lawsuit. One act is here lawsuit in our lawsuit. That is District-Based Entrepreneurship Act law. This is relevant to lawsuit the 2020 notification law. Therefore, I'm taking all these things lawsuit.
What is this?
Lawsuit, the first page, the one lawsuit,
Hmm.
on top lawsuit, it's written 233 lawsuit page.
Yes.
This is lawsuit, the district-based entrepreneurship and professional within bracket, incentive, development and promotion. This is the bill copy lawsuit, but the act is the lawsuit. Act 2015 lawsuit. Under this act lawsuit, if lawsuit see the next page lawsuit, section 3. Preparedness to the district-based entrepreneurs and professionals lawsuit. Section 3 lawsuit. Section 3 lawsuit. The state government shall, in its development and welfare-oriented projects in a district, give preference to the district-based entrepreneurs and professionals to secure equitable distributions of state developmental work among different categories of entrepreneurs in project works up to or involving such amount as prescribed in the schedule hereto. The government may lay down such other norms as may be prescribed in this behalf for effective implementations of promotional scheme. Then lawsuit will turn to next page lawsuit. Here lawsuit will find the preference, local for vocal preference lawsuit, that may be because it's very connected lawsuit. No.
Where is that?
Next page. Next page. Can you see the
Next page means 235. Schedule.
235.
Schedule.
No, schedule lawsuit. Here for the contract work up to lawsuit 50 lakhs lawsuit. All registered contractor in class 5 and class 4 category domicile within the territorial jurisdictions of community block of that area lawsuit. The preference is given to the contractor or entrepreneurs who are residing within that block lawsuit. Now above 52 so and so, all the registered contractors in class 1, class 4, and so category within territorial jurisdictions of assembly constituency lawsuit. Likewise, it goes up to lawsuit 10 crore lawsuit. Now it has been amended lawsuit. It has been amended. Now it kindly see the 6th one lawsuit. 6. Above 10 crore, Now it's 20 crore lawsuit. Amendment has been made. All registered contractor in class 5 and so and contract eligible for national and international competitive bidding lawsuit. Then kindly take up the next lawsuit document.
What are you trying to say?
Lawsuit, I'm coming lawsuit.
Present
Kindly
contract is 99 crores
99
and this locally thing will apply only up to 20 crores.
a lawsuit. Here, look, can you see?
Is that what you want to say?
See, yes.
Huh?
Kindly see the next document which I have. This is the rules frame under the Act lawsuit.
Yes.
Then lawsuit will find here lawsuit 2, section 4(2) on next page, down below. The contractor oblique entrepreneurs before participating in the tender must satisfy the following conditions. On next page, second page, lawsuit.
I've seen it. Yes. Read.
Here, lawsuit, the district-based independent professional must be duly registered under Arunachal Pradesh Contractor Enlistment Rules 28 in the appropriate class of category, and that the registration must be valid on the date of participation tender, a copy of which must be submitted to tender authority. Lawsuit, so far this preference is concerned lawsuit up to lawsuit for 20 crore lawsuit. Is preference given to the district-based lawsuit and the local the entrepreneurs or contractors of the state lawsuit. Now kindly come to next page lawsuit. This is the amendment made in year 2020 lawsuit. And kindly come to next page lawsuit. I would like to take lawsuit to some amendment changes have been brought so far amount is concerned lawsuit. I'm taking lawsuit to the serial number 7 lawsuit. Above 20 crore, open to all eligible registered contractor in appropriate class lawsuit. This restriction has been lawsuit done away lawsuit. Now present tender is of 99 crore lawsuit. And this is the Act lawsuit which permitting the lawsuit participation of all the eligible bidder for the tender which is the amount of which is more than lawsuit 20 crore lawsuit. So notification lawsuit of 2020 lawsuit.
Yes.
That is lawsuit for only lawsuit up to the amount where lawsuit preference is provided under the Act. That is lawsuit my lawsuit answer to this so far this 2020 is concerned lawsuit. Now question comes lawsuit. 2020 is the notifications, though it's by me lawsuit, state government. The Act of 2015, which has been amended in 2020, also is my Act lawsuit. Their lawsuit, Act and the lawsuit notification, which is the executive order in nature lawsuit. Definitely lawsuit, the Act has to be lawsuit advanced by this court law. Court of law lawsuit. That's my understanding lawsuit. Now, this is lawsuit, what I understand in respect of the 2020 notification issued by the state government. And one more thing lawsuit, apart from this Act lawsuit, general financial rules is applicable in the state of Arunachal Pradesh, and there is a statutory rule lawsuit. And in that statutory rule lawsuit, publication through the e-portal is the mode and the manner prescribed. That cannot be done away by the executive order. A settled position laws, though both are mine lawsuit. For this honorable court to examine lawsuit, that aspect has to be seen because this honorable court has to advance the more valid law.
Yes.
Now, next is lawsuit. So far, what is the basis of submission and prayer before that lawsuit to have the publication in the newspaper lawsuit? As yesterday also I have pointed out lawsuit. That is lawsuit Clause 17 of the lawsuit CPW manual 2014 laws. This is the only basis, lawsuit, apart from some judgments which have been placed today. If lawsuit see the pleadings, lawsuit, 2014 CPW manual is the basis only. Where it says lawsuit, apart from lawsuit publication in the webpage lawsuit, also newspaper has to be done lawsuit. Now I would like to place lawsuit. Let's go to the second. Kindly see the CPW manual 2019, this one also. I'm taking lawsuit to the preface, that is at page 4 lawsuit. The 4th page lawsuit. Kindly turn 4th page lawsuit. Page 4 lawsuit.
4.
From beginning past second third, its pagination is not.
No, pagination is there. 1, 2, 3, 4.
Pagination lawsuit
It's in black.
is 5 lawsuit.
Hmm?
5. On bottom on bottom lawsuit, right hand side lawsuit, 5 is yellow. See, I'm taking lawsuit to the preface of the book lawsuit.
Where?
From beginning lawsuit, past second and third and fourth page. From very beginning.
Page number. You tell me the page number. Roman numbers.
Yeah.
Huh?
Yes. This
Below
one.
that black thing, what is that? Roman number?
This is 5 lawsuit.
5. Okay, it's a preface.
Yes, preface. Preface.
You want to see,
Yes,
read the preface?
Yes.
Yes, okay.
CPW works manual was last published in the year 2014, the 14 which the petitioner is relying on. Over the years, various guidelines have been issued on procurement policies by the Government of India. GFR 2017 has also been brought out, which further enable an efficient and effective framework of fiscal management while providing necessary flexibility to facilitate timely delivery of services. Further, need to bring out changes in CPWD, especially the need for business process re-engineering has been engaging the attention of the MOSO and so. In the above background, the Ministry of So and so commissioned a study on the working and organizations of CPWD through An and Young So and so in May 2017. The objective of the assignment was to entirely to study in detail the working of CPWD, keeping in view its mandate and function, and to carry out an analysis of its structure and organization, and to suggest measures for enhancing the efficiency and effectiveness of the organizations by ensuring optimal utilizations of the resources. One of the prime recommendations of E&Y was to redraft the CPW work manual in the line with the latest trends in the construction sector and global best practices, and to make it concise, effective, and delivery.
Mr. Tapain, why are you reading this? What do you want to say?
Hello, sir. Next paragraph. Next paragraph.
We end up reading the whole thing.
I'm sorry. I'm sorry. Next paragraph.
Yes.
In view of above, CPW works manual has been rewritten and revised as CPW so and so by making major conceptual changes in that. But what I'm saying, the 2014 has been rewritten and that is revised and superseded by this very 2019. That's what I just wanted to point out.
Okay, so what does 2019 provide? That there should be no publication.
Yes, Lord. Same thing
Newspaper.
in 2022 also, same thing is there, Lord.
Which is the relevant provision?
Relevant is Lord said. Chapter 4.
Clause.
Kindly come to page Losif 21.
21, yes.
Chapter 4 Losif.
Yes.
Losif will find 4.4.
Yes.
It's also annexed in the read petition.
E-tendering.
As per rules so and so, rules so and so. The GFR. It's mandatory to e-publish all the tender inquiries, requisite for proposal, requisite for expense of interest, notices, notice for pre-qualification, registration, or any other notice inviting bids or proposals in any form, corrigenda dion, and details of bid above on the Central Public Procurement Portal, as well as website of the department, and to receive all bids through e-procurement portal in respect of all the procurement respectively. However, individual cases where confidentiality is required for reason of national security, such provision would be exempted. The decision to examine any case on the said ground should be approved by the Secretary of Ministry of Legislation and so with concurrence of the concerned financial way. And two also same thing has been provided lawship. And lawship, if turn to lawship 4.12 lawship. lawship. That's it, page 25.
Yes, publicity of tender.
Publicity of tender lawship. All the tenders of any MSL be invited through e-tendering system. Notices for all the works, irrespective of their value, shall be published in the website and so as instructed from time to time. Once published on the website, the tender notices will also become available in so and so through system link. Sample notice for inviting tender forming part of NIT and to be posted in a website given so and so, the SOP lawsuit. This is the format lawsuit. In exceptional cases, if press publicity is required to be given apart from the website publicity, written permission shall be obtained from the next higher authority. Here, rather for paper publication, then permission has to be taken lawsuit. Otherwise, lawsuit, normal rule is that
So now question is, why are you publishing in the newspaper?
lawsuit.
Why are you publishing in the newspaper
Lawsuit.
in other cases?
Yes, I have submitted lawsuit. There are instances, there are so many.
There is no consistency. Sometimes you're publishing, sometimes you're not publishing.
Therefore,
Okay, if you're following this, follow it in toto.
lawsuit.
Why are you publishing? Because you know, you are also aware of the fact that this is not a wide publicity enough. That's why you're resorting to this. Otherwise, what other explanations can be there?
Therefore, lawsuit.
Isn't it? See, page 267 onwards. They have taken pain to annex all these documents. What do you say of these documents? These are your documents, PWD, Government of Arunachal Pradesh, NIT. If you are following PWD strictly, did you take permission for this publication?
Lawsuit.
You can't say.
On this lawsuit, as
How
I
will you say?
submitted lawsuit. Because in addition to lawsuit,
I understand, Mr.
submitted.
Tapin, your endeavor is to impress upon the court that PWD is applicable. We have followed that. What is wrong in that? Yes.
and as I've submitted lawsuit. Now, it's not case that lawsuit, no, only one bidder has come lawsuit. 4 bidders, they submitted their bids in this case lawsuit. Basically, lawsuit will find it's up to the 10, 2, 3, 4, 5, 6, because it's a big lawsuit.
So you see, you say it's a specialized contract work,
Lawsuit.
turnkey project,
Lawsuit.
all these designing, everything has to be done by the contractor. Okay. But you're not bound to choose a particular contractor, isn't it? Of all the bidders, amongst the bidders, you will examine who's capable, who's bidding, or who has got the expertise to carry out this contract. You are free to choose.
Lawsuit.
There's no restriction as
That
such.
is their lawsuit.
It's up to you.
That
Only
is their-
question is, why not invite openly for everyone?
So
You have chosen not to.
just only I'm repeating lawsuit. Because to my understanding lawsuit, we have to be abided by lawsuit, abided by the lawsuit, set norms which we have formulated lawsuit. Beyond that, lordship, if we have acted something, lordship.
I agree to that. There's no
I-
dispute about that. But then again, the question comes, why not in other cases also? That consistency is not there, na?
Lordship, that
What
cannot be-
explanation do you have for that?
No, that cannot be basis, lordship.
Tomorrow again, you may go back to publication. They say, no, it's required. Day after tomorrow again, you say, no, we'll only go for this e-portal.
Lordship, by that publication, additional publication, was anyone, lordship, prejudiced? No one, lordship. Had it not been published also, lordship, the same situation, lordship. Only question is, lordship, whether we have followed or not the given norms. Now, lordship, the lordship will see, lordship, there are so many judgments, lordship.
Yes, what are,
Were in contact, in the
what are those
contact-
judgments?
Contact matter, lordship.
Uh-huh.
Until unless, lordship, overwhelming, lordship, the public interest demands, lordship, the interference of this court, lordship. Now, in the present case, lordship, hospital is about the constructions of the lordship hospital, which is urgent in nature, lordship.
Correct.
It's not the case that, lordship, the petitioners, the persons who took participation in the NIP, lordship, they are not eligible. And it's also, lordship, the allegation that, lordship, some malafide action has been done. Malafide also has not been, lordship, raised in the writ petition, lordship. It's a bona fidely we have done, lordship. Though maybe, lordship, it's only about, it's not about the non-publication. We have published, lordship. That may be not a lordship. And on the other hand, lordship, suppose say if we allow also, it's not sure that, lordship, how many bidders will be coming up. It's not sure, lordship. May it go lessen also, lordship. It may go up also, lordship. Because pace is there, lordship, whether these two bidders who have been recommended, whether they are eligible or not. Their, lordship, eligibility has not been questioned here, lordship. So how the public interest will be suffered, lordship? If retender is allowed, lordship, then, lordship, the individual interest of the bidders will be there, lordship. They will have the opportunity. But the other side, lordship, public interest. How the public interest will be, lordship, will be benefited, lordship? That has to be seen. Because public interest will not be benefited, lordship. The right of the bidders to participate, that will be their, lordship. But when the situation like this, lordship, the balance has to be seen, lordship. The balance is, lordship, when there is no malafide, or when there is no case that has not been published at all. And in the present case, lordship, some citation has been placed, lordship.
Yes.
If lordship see, I'll place my citation, but before coming to that, lordship, lordship, one citation, Subodh Das versus State of Assam, lordship, that has been, lordship, given. Here, lordship, there was, lordship, the procedure was not followed, lordship. No proper publication, lordship. Under this circumstance, that order was passed, lordship. And order was that, lordship, to proceed apace by following the due process. That was the direction. And lordship will see SPN Enterprises versus State of Nagaland others. Lordship has rightly pointed out, lordship. Only the NIT was hanging on the notice board, lordship. It was not published. Therefore, Honorable Court has observed, lordship. NIT was neither published in newspaper nor in mass media, lordship, or has been used, lordship. But here, lordship, is not that, lordship, we have not published. We have published as per the set norms.
Yes. What are your citations?
Lordship, and lordship, so far ML Enterprises and State of Arunachal Pradesh 2018, this is judgment of lordship 2015, lordship. Before coming of the lordship, this amendment and all, lordship. Kindly see that GFR lordship 2017. Because that time lordship news publication was there. Because newspaper publication, that the print media publication has been done away by 2019 CPW manual laws. And this judgment is prior to lawsuit 2019.
Yes.
Then
What is that? The judgment you want to rely upon.
lawsuit, before relying this lawsuit, since I tried to raise yesterday, but lawsuit has to some extent objected lawsuit.
Which one? Which
This,
one?
no. Before
99?
coming to this citation laws, before coming to my citation, just so for the eligibilities of the petitioner law.
Yes.
Kindly come to lawsuit. IFB lawsuit, that is it page lawsuit 51 lawsuit, 51. Page 51 lawsuit.
Yes.
Lawsuit will find on next page lawsuit the criteria of eligibility for bidders lawsuit.
Where? Which paragraph? Clause.
The first clause lawsuit
Huh?
at page 52, 52.
Yes. What is the number of the clause?
Criteria for eligibility of bidders lawsuit at page 52.
22.
52, 52.
52.
52.
It starts with paragraph 34.3 or clause
No lawsuit. I am in this
403.
403. lawsuit.
What page you say?
It starts from page 51 lawsuit. I am taking lawsuit to the page 52 lawsuit.
52.
Lawsuit.
Yes, yes.
Here lawsuit will find the criteria of eligibility for bidders lawsuit.
Ah, correct.
Now lawsuit bidders, first criteria is lawsuit. The bidder should have satisfactorily completed the work as mentioned below during the last 7 years ending previous day of last date of submissions of the tenders lawsuit. Then next lawsuit, 3 similar works, each of value not less than rupees so and so and so. This also may be noted lawsuit. Then I'm taking lawsuit to the next lawsuit. The contractor oblique bidder should have an experience of successfully or substantially completing at least one building project or civil infrastructure project on engineering, procurement and construction or design and building mode or turnkey mode in last 7 years, ending last date of the month previous to the month in which tenders are invited, costing not less than so and so. Lawsuit, these are the eligibility criteria to participate in the 2 is very important lawsuit. Now, what I'm trying to point out is that lawsuit, the petitioner must satisfy this honor code lawsuit. First, he fulfill all these criteria lawsuit. Simply being a class 1A is not suffice lawsuit. If you do not satisfy this honor code, that you fulfill all these criteria and you are eligible, you are not aggrieved party. You does not come under the definitions of the aggrieved party.
You just a minute. You were reading this paragraph 1.
One lawsuit.
Which part was where you reading?
Paragraph 1 lawsuit. The bidder should have satisfactorily completed the works
Then
as mentioned. Then next lawsuit down below lawsuit.
continued where?
Lawsuit.
Which part?
One lawsuit. The entire one is about the lawsuit. The satisfactory completion of the work.
Yes, yes. And
then to next below lawsuit. The contractor oblique bidder should have an experiences of successfully or substantially completing at least
number 2. 1 as well as 2, isn't it?
Lawsuit. Two is in just in the bottom. It's
yes.
And this 2 is more pertinent lawsuit. Likewise, lordship, other eligibility criteria are there, lordship. In the pleadings, there is nothing, lordship, if petitioner fulfill all these criteria, lordship. Now, even if it's retender also, lordship, retender is permitted also, lordship. This petitioner must satisfy this one. I am eligible to participate. That is not their lordship.
Will that not be the next step?
Lordship.
Will that not be the next step, whether they fulfill or not? You are not debarred from scrutinizing.
No,
Supposing once they participate,
this is lordship.
or you're saying that first they have to satisfy this, then only they can come and file writ petition.
Lordship, so far, bidders should have satisfactorily completed the work as mentioned below, and so lordship. This is, lordship, the criteria. On page, lordship, it is to be their lordship to participate. So far, other lordship conditions are there, lordship. That may be of the letter is saying, lordship.
I understand what you're trying to say. To
No.
show that they have locus,
No.
they must satisfy this.
Satisfied this, lordship.
They don't have that.
Lordship.
They have not done that. So
They have not done, lordship.
they have no right to file the writ petition.
Lordship.
Yes.
So, this my
Then we come to the citation.
last leg of submission.
I think we are
Then my
almost-
submission is
Almost lunch break is there. Now, so I think better close up.
1991, 1 SCC,
Yes, 1991.
1 SCC, 492 lordship. That's Ronak International Limited. Yes, lordship. Yeah, up there.
Paragraph.
Paragraph 11. Paragraph 11 onwards, lordship.
11 only.
11 onwards, lordship. 11,
Onwards.
11, 12, 13, 18, 24, 25, and 27 lordship. Here, lordship,
Mm,
on the proposition that lordship,
mm.
if the one is not here, lordship, both the bidders were not eligible, lordship, in this particular case, lordship. But by relaxing some condition, lordship, one was recommended, lordship. The petitioner's challenge, because relaxation has been given in respect of the one, but you have not, lordship. But otherwise, he was not eligible, lordship. Honorable Supreme Court said, lordship, the person who is not eligible, lordship, he cannot, lordship, challenge. That is the lordship, one of the proposition, lordship. Other one is, lordship.
That is the normal rule which is followed in a writ petition.
Lordship,
You
we have to,
You cannot come and challenge somebody's appointment order just like that,
to show-
unless you are able to show that you are qualified and you've been deprived, isn't it?
lordship.
We're not here to examine each and every case. So that is the normal rule. Unless one shows that you are eligible and you are qualified to be considered. Yeah.
Lordship,
Otherwise,
court of law has to.
there will be no end
has to
examining.
rest on some has to rest on some sort of law, lordship.
So this judgment is regarding that only, is it?
Lordship, and that apart, lordship, the interim and the independence as to the public contact, lordship. Until unless, lordship, there is a demand of overwhelming demand of the public interest.
Public interest, all right.
Lordship. And stay must not be granted. That is another concept proposition laid down here, lordship, because that will delay price escalations. Ultimate sufferer will be the public, lordship. So, just I'm referring this paragraph, lordship, as I pointed out, 11, 12, 13, 18, 24, 25, and 27.
11, 12, 13, 18.
18, 24, 25, and 27. Because petitioner has to come for his right, lordship, violation of his right, lordship. If one is not locus, has no locus, lordship, if he doesn't come under the definitions of aggrieved party, lordship, then, lordship, basically writ court does not give remedy, lordship, because this is not going to be going to benefit the petitioner. Therefore, petitioner must satisfy this one called, lordship. He is eligible, lordship. That's all. Apart from that, the records is available with me, lordship.
Yes, you give the records.
Oh.
May I just?
My lord.
Just a minute, the other party is the respondent. You wait for your turn.
I am the beneficiary of the contract and I have my limitations before your lordship. So I'll stick to these limitations that have been, I have derived through this writ petition. The NIT that my learned friend has been talking about, your lordships, has to be understood in two different modes. This NIT relates to a complete.
Just a minute. You are Mr.
I'm RB Fukan. I appear for defendant number 3 or
RB.
4. RB Fukan.
B.
Yes.
B for Bombay.
B for Bombay. And I appear in
WPC.
this is 376 of 23. Defendant number 4.
Respondent number 4.
Sorry, respondent number 4. I am the beneficiary of this contract.
You're L1 or L2?
L1.
L1. Okay. Yes, you were saying?
Yes. This contract has two very important facts. One, it relates to a public issue, which my learned friend and both the parties are arguing here. It regards to a hospital. The second part is the ingredient in which this construction is to happen. There are a lot of facets. It is just not one part where it has a civil, or it doesn't have only one engineering part of it. It is a contract which complies of a lot of other elements. That is why it forms an EPC kind of a contract. So the qualifications and eligibility criteria of a person is just not based on procurement, which is only one part of the contract. The question falls before your lordships is whether a wide publication is required for a contract as big as this. In the year of 2023, your lordships, a person who is a contractor in Jammu and Kashmir can participate in Tamil Nadu. Not because of wide publication by a newspaper. Publication today means whether it is available to the naked eye for a person who is in that industry. It's a facet construction. We are talking about some contractor who knows the business that is involved in this hospital product. Today, I might be in Arunachal Pradesh. Tomorrow, I might be in Punjab. If I have the eligibility criteria, I can participate anywhere in India. That's the basis of a contract when we say it's an open tender, which participates more people to come into a state for better construction and better quality of tender. Today, in an era where we are talking about and construction here, 3 or 4 people or 5 people who come from different parts can participate. Does it mean that it has to be published in the newspaper for somebody in Jammu and Kashmir to see? If it relates to his area, he knows the CPU which is available. He will go into the internet site, see the tenders available for the state, pick up a particular state and a department and apply for it. Now, the apply is the second part, where we talk about eligibility of a contract. Most of the contracts nowadays, our lordships, are all e-tender. For example, even the High Court tenders, they are not published in newspapers. They're available in the website. Any contractor who wants to participate is welcome to participate. That doesn't necessarily mean that in that state you need to publish it. No. Publication means if it is available for the person concerned to participate, a wide participation through something existing. Now, the department today decides that in this contract, we go by a mode which is specified by the department in regards to an e-tendering. They follow the CPW norms. Norms are established. These norms has to be followed. That my learned friend has already established, your lordships, that what is the norms that is to be followed. Now, coming back to the question is the eligibility criteria. My learned friend in this writ petition says that he's a contractor who is eligible and equally situated like me. How do we come to that finding? Has he participated in the NIT? Does he say the eligibility criteria is wrong? He does not come and participate. He takes the backhand of a person who participates and rejected. He doesn't come before your lordships to say whether this is a wide publication, whether this is to be required or not. He's sitting behind. He should come. That question was rightly put by your lordships. Why are you defending his NIT? If he does not qualify, if he has been disqualified for reasons mentioned in that list, he should come forward. But for a person who does not participate in an NIT, who we are now presuming does not have an eligibility criteria, can he come and question an NIT of this facet? Not even participating. He says that it is not widely published. What were you doing? You belong to this trade. You know what tenders are coming up. This is a very big tender, a very prestigious tender to be participating. And he today says that the eligibility criteria, I can go and perform a contract of 100 crores. Where is it? Where do I see it that you can perform? You've not participated. You talk about Article 14. Where is the question of violation of Article 14? Yes, you participate, you get rejected, then you challenge the decision-making process. What right does he have to challenge the decision-making process which the government has already taken in the benefit of the people and the state? Can he come before your lordship with this at a stage where a technical has been taken up, financial has been also been taken up? Only thing left is the work order. First thing he comes with a writ petition dismissed by your lordships, saying that there's no locus. He comes back again and replica writ petition in behalf of somebody whose tender has been rejected. Did you come up? Did you participate? You have a representation has been sent by the all contractors on 6th of July. They sit down till 29th of July to file a writ petition. They don't come up before that. They wait, let the technical bid open. That fails. Comes the second writ petition after the financial bid is open. What is your effort? You want to stall a process which is for public. You yourself said it's for the public. If it is for the public, will you stall a process by not participating in it? Can an interim order protect him when he doesn't even have a qualification? We do not know as of now because there's no document to say. You cannot challenge a decision-making of a process if you do not participate competent or equally situated. This has been laid down. Can under 226 your lordship decide that? Let him participate. Today he says that the retender happened. An entire process, a government machinery is involved. This is not a tender for 10 crores. It is a tender which is hugely published. Somebody who's qualified under the strict qualifications have come up. They have been scrutinized. There is pre-bid meeting. There is a process which is followed. He's not come and challenged that process. And how will he challenge? Because he's not participated. He has no qualifications to do that. And my learned friend has rightly said, what is publication? Publication means something which is available for the knowledge. It is available. It's a CPU. It's a huge float of information. Today, technology has gone to a different level. I can participate in any NIT if I'm qualified. I don't need to go to that set and pick up a newspaper from that. No, I don't need to. That's the essence of an e-tender. So that it's easy, maximum participation. Every time it says, anybody can come to lordship, the registered lordships and participate. But I can only challenge if I have the process which is against me. I don't have the qualifications. He doesn't have the qualifications. I have the qualifications for which I participate and I get the L1. He didn't come up. He waited till the last moment. And he comes on behalf of somebody who's been disqualified. And he mentions in the writ petition. All his pleadings are based on that.
The representation was on 6th of July.
6th of July. He's the
And the filing of the writ petition, the first writ petition.
The first is 29th of July. That came up on 31st, and the interim order was passed, and subsequently the writ petitions to disposed of on 7th of August. Then comes the next writ petition.
Okay.
And your lordships in the writ petition, would the lordships be kind enough to come to para 10, page 16 of the writ petition?
Which one?
This is my writ petition,
376. Page number?
Lordship, this is 16, para 10.
Yes.
Lordship, 6 lines from the bottom, para 6, page 16, para 10. Whereas the submission of the bid was till 2 p.m. on 10th of July, and Messrs. Kenge Construction submitted the bid online on so-and-so, acknowledged and recorded in a summary tender bidding open dated on so-and-so, such there is absolutely no scope and chances even on part of Kenge to construction submit the hard copy. Kenge couldn't submit it. What is it? I mean, how does he defend his case? Again, your lordships, if your lordships will come to the next page, 17. The eligible bidders, page 17, 6 lines from the top. Thus, the eligible bidders were deprived of their right to participate and tender bid by the respondent authorities in a very deceiving and calculative manner. More so, the said tentative date has not been given to the table, unlike the other tentative dates with ulterior motive to achieve a target goal for Messrs. So-and-so. And other bidders has been either disqualified in a fraudulent way or has been deprived of the legitimate participation. So it is Kenge. He's been disqualified. He participates. I could have understood he coming and challenging the terms and conditions. It is for his case to lay it out, not his case to come up to this court. Para number 16. Page 20. It is pertinent to mention here, petitioner is a qualified registered firm and ready and willing to participate in the bidding process, but due to time constraint, deliberate adopted by the respondent, the petitioners could not participate in the bidding process. One eligible bidder so and so somehow participated. Somehow.
Which was that?
Para 16, page 20, Your Lordship. That's his petition, the statement that he's made. But the same was rejected. Why was it rejected? That's it. That's the summary which is given at page 142. Somehow participated. You knew about this tender. It was available. There was a pre-submissions available, bid discussions. It was available. You send a legal notice on behalf of yourself, yet you don't come. And now my learned friend says that the entire process should be redone. Where two qualified bidders who are eligible for the terms and conditions have been qualified by participating. And an entire exercise has been done by the government authorities today.
See, petitioner is talking about this Kenge construction. They're not before this court?
Yes, that's what I was trying to say. So this has been done at the behest of somebody else. Can the entire process be stalled? With all due respect, the Supreme Court specifically says if you want to challenge a decision-making process, a process which the government has taken, that also should not be interfered in a normal course of business until unless it is so arbitrary in nature. Is it so arbitrary in nature? It can't be. And there's a recent judgment, Justice Chandrachud judgment, I have passed it on to your lordships. I'll just take 5 minutes to read 2 paragraphs. And why am I reading this paragraph? Is because the entire substance is that today. That is why we are here.
Which is that?
I've just passed it on. This is Tata Motors Limited versus Berhan Mumbai Electrical Supplies and Transport. This is the 2023 judgment, your lordships, passed by Justice Chandrachud. I think lordships have got the Manupatra, I've got the SSC, but the paragraph seems to be the same. I would rely on paragraph number 52 and 53.
Yes.
Yes, may I just read your lordships?
Yes.
Paragraph 52. Ordinarily, a writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer unless something very gross, palpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set the knot, the entire tender process at the stage when the contract is well underway, now this is extremely important, would not be a public interest. Initiating a fresh tender process at this stage may consume a lot of time and also loss to public exchequer to the tune of crores of rupees. The financial burden and implication of a public exchequer that the state may have to be met in course if the court directs a fresh notice to be read should be one of the guiding factors that the court should keep in mind. Next para, 53. The law relating to the award of the contract by the state and public sector corporations was reviewed in Air India so-and-so, and it was held that an award of a contract, whether by a private or by the state, is essentially a commercial contract. It can choose its own method of arrive at a decision, and it is free to grant any relaxation for a bona fide reasons, if the tender conditions permit such a relaxation. Now, if your lordship remember, my learned friend had said and pointed out for 2002 manual, which says online / so the option is for the government either to apply or online or a publication. Now the publication obviously doesn't, as I said to your lordships, is not necessarily one method. It can be a numerous others of methods that can be adopted in online. Yes, no, that's also done away with. If corporation and it was further held that the state in its corporation, instrumentalities and agencies have a public duty to be fair to all concerns. May I just read that line once again? It can choose its own method to arrive at a decision, and it is free to grant any relaxation for a bona fide reason if the tender conditions permit such relaxation. It was further held that the state and its corporation, instrumentalities and agencies have a public duty to be fair to all concerned, even when some defects are found in the decision-making process the court must exercise its discretion under 226 with great caution and should exercise only for the furtherance of the public interest. Let me say there is a process, a deficiency, which I don't even consider to be a deficiency when the government is taken and undertaken a process as big as this. Even then there is a restraint.
Mr. Pukan,
Lordship, please.
I think we're out of time now.
I understand.
It's
I just leave it to your
okay.
Lordship to that.
Ah. We'll have a break. We'll come back at 2. Who else is there? You're there. I think it's the same submission, isn't it?
We're
You're
together.
Okay,
Yes.
you're together. I'll have a short reply from the petitioner, then can close up the matter. All right?
Extremely grateful.
27 and 28. The last item to be listed tomorrow, madam.
This is today's list. What happened to this?
I don't know what I did.
Yes.
Yes, my lord, I would like to make mention, item number 27 and 28 to be listed tomorrow. Last item, this is last item.
This was taken up yesterday, isn't it?
My
Was
lord,
it, was it taken up yesterday?
yesterday it was mentioned for today and it was not listed in the regular court list and it, in the morning I found it has been listed.
All right, please write down as paid for by Mr.
M. Nibo.
M. Nibo.
Hmm.
Let the matter be listed again
Tomorrow,
tomorrow, first day, 24th.
most obliged.
Item 27 and 28.
Most obliged, my lord, most obliged.
My lord, this is not actually time to mention.
Yes.
But even then, but considering some some problems, may I request that this may be fixed tomorrow, my lord. Similar
Which matter?
item number 18, my lord. Supplementary hearing.
18. This is a supplementary hearing.
Yes.
Who's for the other side?
Yeah, I am for the private respondent. So we have.
What is the issue involved here?
Service matter, man.
See, if it's a short matter, we'll do it, but if it's a lengthy matter, it may not be practicable.
If time permits on tomorrow.
All right. As paid for by Mr. T. Saw, Learned Counsel for the petitioner, list the matter for hearing again on 24th of August.
Much so.
Yes. Have you completed? All right. Yes.
Already out. So that's my only humble request that should be considered. Grateful.
Yes, you wanted to reply?
Yeah, my lord, only just 2 points, very shortly, my lord.
Okay.
That is on the notification of 2015, the state government has mentioned about the Arunachal Pradesh district-based entrepreneurship and professional incentive development and promotional act 2015, my lord.
Yes.
But to us, all the provisions and terms and conditions mentioned in this act, my lord, will not be applicable in the instant case, my lord, because at page 34 of the writ petition, my lord, they have struck up this act in the NIT itself, my lord. Your Lordship may kindly fair space for 34, my lord, of WPC 376, my lord. Page 34. In the NIT, my lord, this act has been struck off. So all the provisions mentioned in this act will not be applicable in the instant case. My lord. Only 2014 CPW the manual will apply, man.
CPWD manual will apply.
Yes, 2014, my lord. And the 2014 CPWD manual, my lord, mandates that the NIT should be published both in website as well as in fresh, my lord. This is mentioned at, my lord, page 148, my lord.
You know, what about the CPWD manual 2022?
22.
Which one will apply?
Yeah.
And what is the difference?
In any case, my lord, the notification of 19 August 2020 is still in force, my lord, because that has not been either recalled or modified.
Which notification?
2020, my lord.
2020.
Yes, this is page 193, my lord. Because this has not get exhausted as on that, my lord. Whereby it is, my lord, mentioned that tender should be plotted in a normal way. There is no order as such or notification superseding this notification, my lord. So in our case, this will apply, my lord.
Okay, now what about that? Where is that? CPWD manual. Have you enclosed that in your writ petition?
Yes,
or
my
it's in
lord.
the other one?
Page 148, my lord.
148.
Yes. Page 1.
This is 2014, correct?
Yes, my lord.
Now, in 2014, you are referring to which particular clause?
Clause publicity of tender, clause 17.1, sub clause 1, my lord. Wide publicity should be given to the notice inviting tenders. Tender must be invited in most open and public manner possible by advertisement in the website, public press, and by notice in English, Hindi, and the written language of the district, my lord. So
this is 2014.
Yes, my lord.
Correct.
Yes.
Now, where's the other one? The 2022.
2022, my lord, I have not annexed.
Now, what is the other CPWD manual? Which is the latest one?
In another edition.
What is that? Which year? Of which year?
2019 and 22.
Okay. Is there any provision as such? Just show me the page. Which is the page?
Internal page 29 of the 2022 CPWD work manual. It's
No.
clause 4.12.
No, it's
Lordship, page 192, Lordship.
192.
Lordship. In the petition number 403, 192, Lordship.
This is 2014. Correct.
192, Lordship.
Then
fine.
196 is 2019. Is this the latest 2019?
No. Kindly see the 208.
208.
Lordship.
208. This is 22.
22. Lordship.
Any such kind of provision here?
Yeah, provision is here, Lordship.
Regarding
come to page-
white publicity?
No, that is not there. That has been done away, Lordship. So for paper publication is concerned. Clause 17 of 2014 CPW manual, Lordship. That has been done away, Lordship. Therefore, I took Lordship to the preface of 2019 CPW manual, Lordship, earlier.
14 or 19?
14 has been so per paper publication through print media is concerned, Lordship. That is provided in the 2014 CPW manual, Lordship. That has been done away by 2019, Lordship. After 19, Lordship, 22 also has come, Lordship.
Okay.
In 19 and 22, Lordship, both provides for e-publication only, not the paper publication.
19 speaks about 4.4 e-tendering. 4.12 is publicity of tenders.
4.4 and
Which is also
4.12.
another e-tendering.
Yes,
And
4.4 and 4.12 was it.
Correct. In
And in this 2022 CPW manual lawsuit, it is provided in 4.4 and 4.12, the same clause lawsuit. No changes have been made in this 2022. So far, this e-publication is concerned also. In other clauses, some changes have been brought, but so far e-publication is concerned also. No changes have been brought in 2022.
4.4 and 4.12 remains the same.
Same. And if lawsuit see the 290 page, CPW manual 2019 also has been annexed in this very read petition also. 290 also.
219 is there, maybe. Yes, it is there. 14, 19, and 22.
also.
14 speaks about the publication
E-publication and paper publication.
and paper publication.
And that has been done away in 2019.
19
4.4 and 4.12 also.
and whatever is there, whatever was there 19 has been repeated in 2022.
Yes, same as been repeated. No changes have been brought.
Yes.
But my lord, the one that was plotted in May 2023, my lord, that was of equal amount, and that was also ENIT, my lord. At times they publish in newspaper, and at times if some intervention, my lord, is not made, my lord, it will amount to even monopoly, my lord. Because in any case, in the state of Honor, this is hilly and mountainous region, my lord. Suppose I am, it can be said that I am staying in Itanagar Capital Complex, but I cannot be expected to stay 24/7 and in 365 days in the capital complex, my lord, because we used to go to our village also, my lord.
Correct. That you have already said.
Yes, and so my lord,
besides that, any other point?
one last point, my lord. As regards, my lord, alleging us of representing this Kenge construction and all, my lord. I want to just clarify that, my lord. This Kenge construction was only has been made as a reference, my lord, to show that with the insertion of this clause 16.1d, my lord, even this Kenge construction, who was the loan participant from the state, he was also affected. Only to show that we have made a mention of Kenge construction, my lord. Otherwise, we don't know who is Kenge construction, my lord. When we are equally eligible, my lord, there is no question of representing or filing petition for Kenge construction, my lord. So only that was just a reference, my lord, because the ground of rejection of this Kenge construction came to public domain, my lord, after it was rejected, my lord. So we have just made a reference of Kenge construction. It is not that we are in connivance with him or the.
When did you first come to learn about this tender?
In addition to.
No, just a minute. I'm asking him. Please don't intervene like that. It's not appreciated. Yes. When did you first come to know about it?
My lord, because this ground of rejection, my lord, is provided at
No. Simple question. When did you first come to learn about this tender?
After, my lord, this rejection of this, my lord, Kenge construction, my lord. Because
that was when?
That was
must have a date.
Yeah.
What is the date?
Probably after 14th July. Because this petitioner was at Delhi that time, my lord.
You will go on that probability, probably after that. Yours is 376, isn't it? Your case?
Yes, my lord.
The last date was 14.
Yes, ma'am.
So after that only.
Yes, ma'am.
So it's only safe that you say 14.
Yes.
14 July.
Hardly, my lord, in 70% of the, my lord, parts of Arunachal, there is no even telecommunication, my lord. In absence of that, there is no question of, my lord, participation. Ma'am.
All right.
So,
Anything else?
yes, ma'am.
Anything else?
No, ma'am.
All right.
That's.
Yes.
My lord, yeah.
You come here before the mic.
My lord, my learned friend is alleging me of filing this
Make a
petition
quick
under
reply,
behest.
Mr. Counsel. Just sum up
Oh,
your
my lord,
quick reply,
my lord,
because
this,
we have dedicated much time on this.
oh, my lord, this technical bit was opened on result of this NIT was opened on 14 July 2020. Last date was on 10 July 2023, and
Yes.
result was on 14 July 2020. I came to know about this on 12 July. My lord, I have written to the ARCA on 12 July 2020. It is letter is placed in 169 page number, my lord. May I read the letter, my lord?
No, not required.
Okay. Before, it was uncertain who is going to win the race.
You
Even
came to learn on 12th July.
12 July, my lord.
14 July was the date of opening.
Opening of, at that time, nobody knows who is going to win the
Opening
race.
of technical bit,
Yes, result.
which was followed by the opening of
Yes.
financial bid.
Financial bid was on August 9. August 9, it was published on August 9.
August
And
9.
yeah,
Okay.
on 12 July, I have made a complaint to the ARCA that I was anticipating that it was not circulated in the newspaper, my lord. That I have written a representation to address my issue, my lord.
On 12/7.
On 12/7/2020.
You wrote a representation to?
ARCA,
ARCA.
to the president, Arunachal
Okay.
Contractorist Association. And that time, while I am writing when I went to the office of the ARCA, they told me that they have already made a representation to the secretary, principal secretary PWD. I have written in further request you to provide information and input pertaining to the said NIT. Then ARCA give me more input about it. And again, at that time, publication of newspaper was yet to be proven. On 24th of July, I went to the IPR to ascertain whether it was published in newspaper or not. On 24th July, it was proven. On 18th July, it was written by ARCA to the legal notice was served to the executive chief engineer Pasigat, my lord. My lord, when it comes to the page number 52, they are raising issue about the eligibility criteria. My lord, eligibility criteria, this criteria is about the experience certificate. This is to be determined by the PWD, not PWD, tender opening committee. This question doesn't arise yet, my lord. When I was not allowed to participate in the tendering process, how could experience certificate? I would have produced, I have, my lord, and if it is retender is called for, I will furnish my experience certificate to the tender opening committee, my lord. This does arise here, my lord.
Okay.
Again, my lord, this CPWD manuals is not an act, my lord. It is being regulated in Arunachal Pradesh by the Barsium notification number 19/8 of 2020, my lord, issued by the chief secretary, and the notification dated 30/1/2018 issued by the Director of Information Public Relations Officer, my lord. In state like CPWD manual is not mandatorily, it should be followed, my lord. Any state can regulate it, my lord. Even state like this CPWD is mainly it focused on it is for the central ministries, my lord. Ministry, government of India. But somehow state government is following the CPWD manual, but it is regulated through the notification of the chief secretary and IPR, my lord. And my lord, if NIT, even if it is called for re-NIT, nobody is going to lose anything, my lord. In later stage, it will be a precedent, my lord. They will
plot in the newspaper. Sometimes they will plot in the web portal. When we question, why don't you plotted this in newspaper? They will say, we have plotted in web portal. When we ask them, why don't you publish e-tender in the web portal? They will ask, no, we have published in newspaper. This issue will come up every time, my lord.
Okay. What is this 10th of July? You've given me the date, 10/7?
My lord, this last date of filing of ENAT was over on 10th of July.
Okay, 10th July is the last date.
Yes.
Okay.
And I came to know about the NAT on 12th of July.
No, that you've said, I've understood.
Yes.
10th is the last date, 14th is the opening of the technical bit, 12th is
Yes.
the your knowledge and
Yes.
your representative
Yes.
ARCA.
When I,
And 9/8 is the financial bid.
yes, yes.
Okay.
I was not know at that time, nobody knows who is going to win the race. Then how can they say that it is, I have been filed on behalf of Kenge Construction. Even if Kenge Construction win the race, I will come. Definitely I will come to challenge this NIT. That's why I have written to the account 12 July, my lord, before opening of the e-tender. Opening of the reserve, my lord. My lord, if this is nobody is going to incur any losses. Rather, it will benefit the state government, my lord. If they will participate, my lord. Who knows that they will also again win this. My lord, if it is adverse decision is being passed, my lord, it will be overrule the judgment pronounced by this on
All right, all right. So I think that's it, your case. Then who has produced this NG projects? Somebody relied upon NG projects?
No, I don't know MG project, my lord.
NG projects.
Yes.
One copy is lying here in the file. Who has produced it?
I have produced SPN versus State of Nagaland.
No, that I've noted down.
Yes.
Whatever you produce, I've noted down. Okay, so I'll consider the submissions and pass necessary orders.
Okay.
Although I would like to pass the order now, but I think due to paucity of time, I'll just reserve it. It should be out within a day or two. All right. Until then, I think status quo will have to maintain.
Okay.
There's no other option. So please write down. Heard Mr. N. Pada, Learned Counsel for the petitioner in WPC number 376 of 2023. Comma, Mr. K. Potom, Learned Counsel for the petitioner in WPC number 403 of 2023.
Yes.
Comma, Mr. S. Tapin, Learned Senior Government Advocate for the official respondents in both the writ petitions. And Mr. S. Pukan, R.B. Pukan, Learned Counsel for respondent number 4 in WPC number 376 of 2023. Anybody else? I think that's all. All right. Next para, hearing concluded, judgment reserved. Mr. Pat, what about the status quo? It's still today. What is to be done?
My prayer is also that may not become. Because on the face of the record book.
My lord, in the given circumstance, my lord, the status quo will prejudice known for the my lord, can be allowed to be maintained by the.
My lord, this private respondent may incur financial losses also, my lord, if it is not maintained. They may go ahead with the work and made some investment.
No, you're concerned about your respective cases. I'm concerned with whether I can say status quo till passing of the judgment.
So my prayer is not complete.
Hmm?
On the page, it may not be complete. On the page was a I am submitting. We have complied. Publication.
This is the confusing one.
We have not published it all.
My lord, in absence of temporary restraining order, my lord, since we have prima facie established oblique motive of the respondent, my lord, the things may become more complicated, my lord.
My lord, what if what the direct DME end user who is going to fund this, they stated that in later on they will stated that we are not going to give the fund to the PWD department. That even there will be a legal tussle between the end user and the executive agency, my lord. Because the DME itself has written that to the PWD department that please you cancel this NIT. We have accept.
Okay,
Yes.
Mr. Tapin, I'd request you to put things on hold. You get the judgment tomorrow or day after, either of these days. So till then you don't, so let there be an understanding, because I'm not going to pass any interim order at this stage, all right? But make it, please convey that don't do anything, because matter is going to come up either tomorrow or day after, you'll know the results, all right? Okay. Yes, next item. Yes,
Yes,
what is this case?
Your Lordship, I am agreed by the order dated 01/08/2023, Your Lordship, having been passed by the Deputy Commissioner at Changlang.
Where do we find the order?
Impugned order is at page number 43 and Annex 1. Starts from page number 43 of the writ petition.
43.
43, Your Lordship.
What is this? This is a judgment?
Yes, judgment and order dated.
In which case? In what kind of case?
The case has been branded as appeal number 01/2023. Now, this is a case wherein the learned Deputy Commissioner Changlang had passed the order without having authority of law, which is an order being null and void, a quorum non-judicial. Lordship may come to paragraph 15, page number 46 of the impugned judgment and order.
Yes.
Paragraph 15. While issuing said LPCs, the additional Deputy Commissioner Bodumsa must have considered the standing structures which was not in possession of the respondents and may have sought explanation from the petitioner to express the reason and ground based on which the said construction done. It appears that the said fact of concerned existence of construction structure was suppressed while issuing these LPCs, and same has been issued without proper verification by the concerned issuing authority. 17 is relevant. Considering all above facts and materials, LPC number so-and-so dated so-and-so and so-and-so, two LPCs issued in favor of Srimati Jalatko Singhfo and Sri Kumnan Singhfo, respectively, are hereby cancelled with immediate effect. These are the two persons who are before this honorable court by way of this writ petition. These two LPCs which was granted in favor of these two petitioners have been cancelled by the Deputy Commissioner. Now, this has been passed without any authority of law. Now, this is an order, judgment and order, the so-called judgment and order, having been passed by the Deputy Commissioner while invoking Section 83, subsection 1, Clause A of Arunachal Pradesh Land Settlement and Records Act of 2000. Your Lordship. Now, it would be pertinent to look into the provisions of Section 83. Your Lordship.
See, before that, this case has been registered as miscellaneous appeal.
Miscellaneous appeal. Your Lordship.
So, is there an appeal?
No, not at all. Your Honor. I'm coming to that. This is not an appeal at all.
No, prior to the Deputy Commissioner looking into this matter, was there any authority who had?
No, Your Honor. There was no case at all. The question of
Then
filing an
Then
appeal,
how did this case come about?
this is what, Your Honor, this is what, I'm coming to that.
No, you tell me just now. It was
This-
filed on a
yes.
complaint by somebody.
This has been registered on the basis of an application filed by the respondents, private respondents. I have annexed it.
Complaint,
Yes,
complaint.
yes, complaint. I have annexed that.
There's a land dispute.
No land dispute, Your Lordship.
And why should they be interested in cancellation of your land?
In fact, I have a plot of land. I have allowed the respondents, the private respondents, to settle over and take possession of the land for a particular period of time. In fact, I have not absolutely transferred the land to him,
Okay.
to the respondents.
Okay.
This is the basic fact.
How many respondents are there?
3 respondents.
And petitioner?
Petitioners are 2 in numbers.
Two.
2 in numbers, Your.
It's a joint ownership over 2 different plots of land.
2 different plots, 2 different individuals are having ownership over that land, and they have possessed the LPC from the additional deputy commissioner.
And in whose name?
In the name of the petitioner, sir. In the name of the petitioner.
Separately.
Separately. They are the owners of the land. They have possessed
There
the
are
LPC.
Two parcels of land.
2
involved.
parcels of land. 2 parcels of land.
Petitioner 1 and petitioner number 2.
Definitely.
Both of them have separate land.
Separate lands.
Separate LPCs.
Separate LPCs.
And the respondents
respondents
are occupying the land.
Respondents,
with the
they were
permission of the
yes,
petitioner.
Yes, with due permission of the petitioners, they have occupied the land. They have occupied the land.
Okay.
But then that very particular parcel of land was never transferred to the respondents. You know,
Okay, it was never transferred.
was never transferred.
So what was their allegation before the deputy commissioner?
The deputy commissioner, before the deputy commissioner, they said that the petitioners had obtained the LPC without informing us, without due procedure of law. That is the only allegation. Without following due procedure of law.
I see.
Without following due procedure of law. And they have filed an application, and that has been branded as an LPC cancellation application. There is no any provision as such, Your Lordship.
But this is a misappeal number 1.
Misappeal number. They have filed.
Where is the LPC cancellation application? Let us go to the, what is the provision? Section
83.
1A. 2000 Act. 83 1A.
Your Lordship, 83, it speaks about appeals. That's chapter 8.
Are we holding the same book? What is the page number?
Page number 245.
245.
Yes.
Yes.
Appeals. Section 83
Yes.
follows from chapter 8. 83, save as they have filed this application under 83 1A. Save as otherwise expressly provided, an appeal shall lie from every original order passed under this act. This is very important.
Just pause there for a moment.
Yes, original.
What is original order? And who can pass it?
That is why there is no any original order. LPC cannot be treated at par with original order.
No, there is no original order. It's a separate thing. But the act says that order passed and appeal life from every original order. So what is this original order referred to in this act? Not in your case.
Yes. Original orders means there are revenue officers.
Who can pass?
Yes,
Who
revenue
can
officers.
pass?
Revenue officers are there.
Revenue officers.
Revenue officers, settlement officers are there.
Okay, so against those kind of orders, appeal will lie.
Appeal will lie.
To the deputy commissioner.
To the deputy commissioner, certain officers have been mentioned therein. There are 4 clauses, A, B, C, and D. A, B, C, and D. They have filed this application under 83 1A.
But you're saying that there's no such kind of order earlier.
First of all, there is no any order. Number 1 thing.
Straight away complaint was to the DC.
Yes, Your Lordship.
And he himself passed the order.
Definitely, Your Lordship.
As
He had
an
passed the
appeal.
order. LPC cannot be treated at par with an order, Your Honor. Because order is altogether a different thing. Now, it says, save as otherwise expressly provided, an appeal shall lie from every original order passed under this act, if such an order is passed by an officer subordinate to the deputy commissioner, Appeal shall lie to the deputy commissioner when that original order is passed by an officer who is subordinate to the deputy commissioner.
Is there any such kind of order here?
No. First of all, there is no any order. And thereafter, additional deputy commissioner, even if we presume for a moment that the LPC are treated to be original order, Now, first of all, we will have to see whether additional deputy commissioner is subordinate to deputy commissioner or not. When we come to
LPC was granted by the
LPC was granted by the ADC.
Additional DC.
Yes.
Not assistant DC.
Not
additional
assistant DC, additional deputy commissioner.
Okay.
Now we
Where
will
are
have
the, where are the powers and functions?
Your Lordship,
DC, additional DC. There must be something somewhere.
yes. The term deputy commissioner has been defined under rule Rule 2 of the 2012 rules.
Which rules is that? 2012.
2012 rules made under section 99 of this 2000 Act.
Where do we find the rules? Is it available in this book?
I'm having the copy of this.
Or rules are separate, not in the book?
No, that is not in the book. Here, the expression deputy commissioner has been well defined, which includes additional deputy commissioner. He is not subordinate, which is highlighted. Your Lordship.
What are the powers and functions of additional DC?
For the purpose of issuance of LPC, there is a notification having been published by the state government, wherein the additional deputy commissioners have been authorized to issue LPCs up to 5 hectares in the respective
All right,
jurisdiction.
Mr. Manto, that is your case. Now, who is appearing? Mr. Ratan? Anything to submit as of now?
No, this will raise very interesting questions.
That is why we'll issue notice and stay this order.
My lord, let there be status quo on the possession of the land. Status quo over the possession. Because
Okay.
there will, I think, not great problem.
All right.
Your Lordship, that particular order has to be suspended. And more interesting is that my other line of argument is that they have filed an application without an affidavit. Your Lordship. Without an affidavit. Not technically.
Mr. Ratan,
Yes.
status quo without staying the order of what? I mean,
Why? Because
it amounts to the same thing, one and the same thing, isn't it?
possession was already with the respondents. Now they have applied for the LPC and taken that land possession party. Possession actually is still with the respondent.
Private respondents.
Private respondent.
Okay.
This is it. Otherwise, that will may, if this simply stay, this might create a problem within them, who will be now in position.
Your Lordship, there may be a stay order and the parties be directed to maintain status quo. That's all. Yes.
All right, heard Mr. C.W. Manto, learned counsel for the petitioner, who submits that the petitioners are aggrieved with the judgment and order dated 1/8/2023 within bracket annexure 1,
Annexure 1.
by which the LPCs land possession certificates within bracket LPCs issued in favor of the petitioners have been cancelled. Stop. The learned counsel submits that the judgment and order was passed by the learned deputy commissioner, Changlang district, against the complaint submitted by the private respondents. Stating that the LPCs issued to the petitioners were unauthorized and in violation of the relevant provisions in this regard. Full stop. The learned counsel for the petitioner submits that the complaint was entertained by the deputy commissioner as an appeal defined under section 83 within bracket 1 within bracket small a of the Arunachal Pradesh open bracket Land Settlement and Records close bracket Act, 2000. Full stop. He submits that as per the said provision, an appeal shall lie from every original order passed under the Act if the same has been to the deputy commissioner, if the same has been passed by an officer subordinate to the deputy commissioner. Full stop. The learned counsel submits that the LPCs were issued to the petitioners by the additional deputy commissioner, and in terms of the Arunachal Pradesh Land Settlement and Records Rules 2012. Deputy Commissioner has been defined to be Deputy Commissioner in charge of a district of Arunachal Pradesh and shall be deemed to include additional Deputy Commissioner as well. Full stop. He therefore submits that the additional Deputy Commissioner who issued the LPCs, not being a subordinate officer to the Deputy Commissioner, the impugned judgment and order passed by the Deputy Commissioner, Changla District, is not sustainable in law. Next paragraph. In view of above, issue notice of motion, returnable by 4 weeks. Mr. N. Ratan, Learned Additional Advocate General, accepts notice on behalf of the respondent. Numbers. Respondent number 2. Who's one?
One is the Deputy Commissioner. He has been arraigned as a party respondent.
Why?
Because without having jurisdiction, he had passed order.
No.
That was apprised. That was apprised to him.
No, you should not. You should not. You make Deputy Commissioner. He has not passed in his own personal capacity as an appellate authority. According to him, he has passed the order, isn't it? He has no immediate personal interest. Don't make him a party like that. You incorporate Deputy Commissioner in officially by official designation if you want to. For that, you'll have to file a missed case. New High Court rules.
Yes, my lord. Otherwise, that it can be struck off. Deputy Commissioner is respondent number 2, official capacity.
The respondent number 1 appears to be the Deputy Commissioner of Changla District by name. To stop, it is considered that impleadment of respondent number 1 by name in the given case is found to be unnecessary. As such, the respondent number 1 is struck off from the arrayed respondents. The petitioner may file appropriate application to implead the Deputy Commissioner concerned by designation.
Already there.
If so advised.
Deputy Commissioner Changlang is respondent number 2, my lord. Already there.
Oh, you are appearing for 2 only.
2 only.
Okay. Then that second observation is not required. Then petitioner to take steps for service of notice upon the remaining respondent.
By Dusty, I may be allowed to do that.
Numbers 3, 4, and 5 by way of Dusty within a period of 10 days from today. To stop, the petitioner shall file an affidavit as proof of service thereafter. To stop. Next para, having regard to the projection made by the petitioners, the impugned judgment and order dated 1/8/2023 shall remain state till the next returnable date. To stop, the parties are also directed to maintain status quo as on date.
Obliged.
Yes.
My lord, the petitioner, my lord, here is aggrieved by the cancellation of the fair price of license.
Where's the order? Page?
Order itself is, my lord,
not there.
71. But before that, my lord, I have.
Order is not there.
Order is there, man.
Show me that order. 71.
Just a moment.
72. Type copy.
Yes.
I hope you have typed it properly.
My lord?
I hope you have typed
Yes,
out
yes.
properly.
Yes.
Normally, there used to be a lot of spelling mistakes. Not in your case. I mean, in generally, when I see one has to revert back to the original document.
Marriage.
Yes.
Whereas a complaint of beneficiaries attached with your FPS
has been heard on 24/7/2023 by the District Grievance Redressal Officer, Mondila, on recommendation of the case against our FPS by ADC NAFRA, in its irregularities found such as 1, non-distribution of food grains to the ration card holders as per the entitlement, and 30 returns on ration cards under custody of FPS owner after disbursement of food grains to ration card holder is a violation of rules under TPDS, that is Targeted Public Distribution System Control Order 2016. And whereas overcharging under women and non-receipt of BPL and APL rice has been stated by the ration card holders, which are the main cause of the complaint, got established during hearing. Therefore, the FPS license of suspension is thus cancelled with immediate effect as per Arunachal Pradesh Targeted Public Distribution System Control Order 2016 under Section 10(7). There was no hearing, my lord. And my lord, this is not an authority, my lord, that is contemplated under this order. That is why I wanted.
What is the first sentence?
My lord.
What is the first sentence? A complaint of beneficiaries attached with your reference card.
That's why, my lord. My lord will see the so cause notice. There were, it appears, written complaints against me. I've been running this FPS for 32 years now. No complaint, nothing. My categorical case is that these complainants are having personal.
Who are the complainants?
That's why, my lord, if your lordship.
No, who are the complainants?
Some ladies of this area.
Ladies, I mean the public from the area,
Yes.
Beneficiaries.
Yes. But
Now-
there has been a meeting thereafter that says we have no complaint against me.
Do you have this Department of Weights and Measures or something like that?
Yes,
No,
yes,
no,
there is.
What do they do? Do they go and inspect all
Yes.
these?
But firstly, my lord, my first ground in this petition is the proceedings is under this, if your lordship may kindly page 27, madam.
What is the complaint against you?
I don't know, that's why, madam. Because the copy was not served upon me. That is my case.
No. How come you say you don't know? Overcharging, underweightment, non-receipt of BPL, APL rice.
Yes, but
These are all the complaints against you.
But my lord, our categorical case is, my lord, the copies of the complaints were not furnished to me. There are more than 30 people gathered.
No, that is something else. You can say that the allegation against me is this. But
If your lordship may kindly page 27 for a moment.
27, yes.
This is, my lord, the Targeted Public Distribution System Control Order 2015. This has been, my lord, framed under, my lord, Section 3 of the Essential Commodities Act 1955. So, my lord, this is a part of an statute. It has been framed under exercise of powers under an statute. Now, your lordship may kindly have two definitions.
Yes.
D, my lord.
Yes.
Appellate authority means an authority appointed by, as such, by the state government under subclause 1 of clause 15 of this order. Then your lordship will kindly have I, small I.
Yes.
Designated authority means any officer not below the rank of Food and Civil Supplies Inspector in the state government. Then your lordship may kindly have the next page. This is the relevant portion I have enclosed. Section 10, my lord. Operation of fair price shops. You know, lordship may kindly have subsection 7 at the next page, page 29.
Yours is the fair price shop.
Yes.
7.
Yes. The designated authority shall take prompt action in respect of violation of any condition of license, including any irregularity committed by the fair price shop owner, which may include suspension or cancellation of fair price shop owner's license. So it is the designated authority who is required to be an officer not below the rank of a supply inspector, who is authorized to pass the cancellation order. And there's a provision for appeal against that. At the next page, my lord.
Who's the authority who cancelled your license?
Designated authority. Your lordship will have the definition again, my lord.
The rank of inspector.
Food and Civil Supplies Inspector in the state of government. I am pointing this out because the Deputy Commissioner has cancelled the license now. I have been, my lord, deprived of an appellate authority. So the appellate authority is page 50, page 30. Appeal, section 15.
Any interim arrangement made here
No, my lord.
after your cancellation?
No.
They may examine your case, but what about the public? How will they get the
No,
complaint?
they are from other FPS they have been asked to.
Where?
Other
By this order?
In the impugn order also, my lord.
It is written somewhere.
Not in that, but it's a peculiar proceedings, my lord. Earlier, the ADC NAFRA had a proceeding. Thereafter, it was forwarded to, my lord, the Additional Deputy Commissioner Bomdila. He passed that order in his capacity as the District Grievance Redressal Officer. That is not envisaged under this order, my lord. But the proceedings is under this order. May I read, my lord, this appeal provision?
Yes, read.
The state government shall appoint an officer of the government not below the rank of additional district magistrate in our state additional deputy commissioner as a district as an appellate authority for exercising the powers conferred upon and discharging the functions assigned to him under this order. Then your lordship kindly have subsection 3. Any person aggrieved by an order of the designated authority denying the issue or renewal of the license of a fair price shop or cancellation of the license may appeal to the appellate authority within 30 days. So this is the provision in terms of the rule, order. And it says no appeal shall be disposed of unless the aggrieved person has been given a reasonable opportunity of being heard. Then your lordship will kindly come. I have typed copy also and enclosed here. Then your lordship will kindly have page 42 for a moment. This is only for the purpose of pointing out the license was issued way back in 31/10/1990, my lord.
Yes, you were saying 30,
Yes.
35 years you have
Yes.
been doing that.
Then your lordship will kindly have the so cause notice.
Page
52. Our categorical case is that the compliance has not been furnished to me. As a matter of God.
Yes.
Whereas many ration card holders under MS such and such has lodged a written complaint against you for practicing many anomalies and irregularities, whereas the allegations include the scale of issue, untimely distribution, retention of ration cards, extraction of exorbitant renewal fees by the FPS dealer inter alia. Whereas such and such were launched with a view to strengthen and streamline the PDS as well as to improve its reach to all beneficiaries in the far-flung, hilly, remote, and inaccessible area with a substantial section of poor target families live. Hence, you are hereby so caused as to why necessary legal actions should not be initiated against you as per the PDS Control Order 2001 and the Targeted Public Distribution System Control Order 2015. For the contravention of said provisions of the order, you are hereby directly attend in person to the reply on fixed 33 June 2023. Then your lordship will have the report at page 53. It's that term is the order sheet. I don't see how it goes.
What is this?
This is some sort of a report, my lord. Though it is reflected as order sheet.
Report by whom?
By the ADC NAFRA, the authority who issued this so-called notice.
No, as per this show cause notice,
Yes.
22nd, 23rd June was fixed
Yes.
for attending
Yes.
in person
Yes.
with reply.
23/7, yes.
What did you do?
I appeared. He asked me. Then there were more than 30 persons there. He took his statements, oral statements, my categorical case. What is your allegation? Then this report. No.
Did you submit anything in writing?
No, my lord, because I did not get a copy of the allegations against me, written complaint.
Did you ask for it?
No, my lord, I was asked to appear on 23rd. I appeared. I was expecting. I have stated it in my petition. that the
No, you
complaint-
appeared,
copy-
but you should have asked, where is the complaint? You
My
want me to
lord.
reply, give me the complaint.
That's what, it's my categorical case, my lord. I went before, I'm a villager, my lord. The additional deputy commissioner of the subdivision calls me up, did not furnish me a copy, asked, this is your allegation, what do you say? I said, I deny it. Then he takes the oral statement of all these persons, and then he submits this report. Subsequently, same thing happens. And my lord, firstly, my lord, this ADC had no authority, my lord has seen the order. It is only the designated authority who could have passed an order for cancellation of fair price shop. On that count alone, my lord, is also interference, my lord. They've taken him in appellate forum now. My lord knows when a statute provides a thing to be done in a particular manner, it has to be done in that manner only, my lord.
But at the same time, it's not that some authority is not competent who has done it.
But he's
It is
not competent, my lord.
He's an authority who is higher than the inspector.
No, no, my lord. How does it take away my appeal that is provided in the statute, my lord? And my lord, my categorical case is I was not even given a copy of the complaint. The gross violation of natural justice, my lord. My lord, we'll see how this goes about this. Oral statements, my lord. My lord, call for the records and see, my lord, what is there. Can the order be passed in this manner, my lord? Just taking oral statements from villagers. Page 53, my lord. He goes on to records who has said what. In the last portion, your lordship will kindly see page 54, the last part. Last paragraph.
Yes.
Hence, after listening to both parties on perusal of available documents and inspection of nearest FPS and seeking information on the operation of the said FPS through beneficiaries clandestinely, my lord. No opportunity to rebut, my lord. Clandestinely. And that is how, my lord, this report was forwarded to the Additional Deputy Commissioner headquarters, come DGRO, which is not an authority contemplated under that order in which the proceedings took place. And ultimately, the impugn order was passed by the Deputy Commissioner, my lord. Page 56, your lordship will find the forwarding. Now, this DGRO is an authority under the National Food Security Act 2013. A complaint was lodged by some beneficiaries on the improper functioning of FPS Khajalang and accordingly summary trial inquiry by the undersigned. Hence, the report is hereby forwarded for your kind attention for necessary action. The report itself says summary trial.
Who is this? The authority who cancelled it?
No,
Impugn
the
order.
authority who had this preliminary trial, summary trial, ADC Nafra,
And cancellation is the Deputy Commissioner.
by the Deputy Commissioner. Deputy Commissioner is not an authority under the Act, my statute. And my lord will see, just for the moment, my lord, after this order, my lord, so many people have come up and said they have no complaint against me. So at least I should have been given an opportunity to rebut these allegations, my lord. I could have brought in my own evidences. If you lordship kindly have page 78.
Complaint was made to the Deputy Commissioner or to the Additional Deputy Commissioner?
I don't need, it appears the ADC, my lord.
ADC.
Appears so, my lord. They were provided with nothing. Choco's notice does not reflect anything. At page 52. My lord, in otherwise also, my lord, prima facie, my lord, the act under which the proceedings have been held has been violated, my lord. They cannot take even appellate forum because it is the rank of an Additional Deputy Commissioner who will hear an appeal of cancellation by the designated authority.
So complaint went to the Additional Deputy Commissioner
Nafra.
who made a summary trial
Maybe, my lord.
and forwarded the same to ADC headquarters.
Yes.
And in turn, the DC has cancelled it.
He also recommended cancellation, similar type of proceedings. Then the Deputy Commissioner has cancelled. Deputy Commissioner is not even an authority under the statute, man. And so many people have now come up and said they have no complaint against me. I should have been given an opportunity, man.
Yes.
I'm praying for a my lord protection, my lord, make a writer that due care be taken in supplying these food grains.
My lord will kindly see at page 60.
60.
Yes, my lord. This is an order after by the ADC Nafra. Page 60, after all finding out the things, my lord, order has been given at order 1, my lord. Now, therefore, detailed examination as stated above and report submitted by ADC Nafra, the FPS license of Sri So-and-so has committed lot of irregularity by not following the guideline of the TPDS. The license of FPS recommends for cancellation under section subsection 7 of section 10 TPDS under order number so dated so with immediate effect. Till such time of appointment of new FPS, it is recommended that the TPDS consumers may allow to draw their ration commodities from FPS number 1 NAFRA, and accordingly the same quota of rations commodities be allotted to FPS 1 branch cooperative NAFRA. Now, my lord, what for today, my lord, what my submission will be, let there be no appointment of a new till the matter is, but also since there are allegations against the petitioner, let them draw as per this. Will adjudicate the matter, which whether these ADCs, so-called ADCs, were the designated officers or not.
No, this order.
My lord,
Just a minute, just a minute.
Care has been taken.
The one we just read out, this is from what?
This is where the ADC headquarters.
ADC headquarters.
In his capacity as District Grievance Redressal Officer, an authority under the National Security Food Security Act.
No, you just come to page 61. It says for District Food and Civil Supplies Officer.
No, my lord, above that.
West coming.
Above that, my lord. Sang Khandu ADC come DGRO.
My lord, what my then why this signature down here?
I don't know, my lord.
DGRO. DGRO means?
District Grievance Redressal Officer, that is an authority under the National Food Security Act, empowered to do totally different things. My lord, if you lordship, you kindly have page 57. Prima facie, my lord, and statute has been violated, my lord. My lord will protect me, my lord. My lord, no law is settled. Once a statute provides a thing to be done in a particular manner, it is done in that manner only, no other manner. And since these rules is framed under powers exercise conferred under the statute, it is a part of the statute. It's a settled law, my lord. As page 57, your lordship will see in the code of DGR, West Cameng District, Bomdila.
My lord, may I, my lord?
Yes.
There is a confusion, maybe, my lord, because the licensed fair perhaps of licenses were as per the section 3 of the Essential Commodities Act. Again, in the year 2015, the Food Security Act 2013 that has come. Now, because of these designations, almost performing the same duties, my lord. Because under, if my lord sees at page 27, this is the Targeted Public Distribution System Control Order 2015, which is under the section 3 of the Essential Commodities Act.
Yes.
1950.
It's framed under section 3.
Yes. That was framed. Now this provides for appellate authority, designated authority. So, my lord, appellate authority, it says, means any authority appointed as such by the state government under subclause 1 of clause 15 of this order. Designated authority means any officer not below the rank of Food and Civil Supplies Inspector in the state government. My lord, Food and Civil Supplies Inspector, not below that. ADC is above that, my lord. That is there.
No.
ADC is above the rank of Food and Civil Supplies Officer in the hierarchy. My lord.
Whatever it is,
now,
the deputy
now, my
commissioner
lord,
passed an order. Where do I go? Assume
again,
Let him submit.
yes, my lord. Appeal also, my lord, at
Yes.
page 30, appeal. Section 15. Page 30.
Yes.
The state government shall appoint an officer of that government not below the rank of additional district magistrate of a district as an appellate authority, not below the rank. Now here, we will have to take instructions as per this order, who is the designated authority and who is the appellate authority. Now, by saying, just taking a technical plea that ADC is not a designated officer, my lord, and it will have he will have no appellate authority, my lord, that
instruction will be required. Now, again, a technical plea is been taken that ADC has acted as a DGRO. That is under the Food Security Act, my lord. If my lord comes to the National Food Security Act, my lord, at page 84, annexure 10, my lord. Same thing, my lord, this, if my lord, 84, an act to provide for food and nutritional security in human life cycle approach by ensuring access to adequate quantity and quality of food at affordable prices to the people to live a life with dignity and for matters connected therewith or incidental thereto. This is then at if my lord sees definition 2, subsection 4, my lord, fair price shop. Here, concept of fair price shop, these are to be distributed through the fair price shop, which are established under the section 3 of the Essential Commodities Act, my lord. Now, in this, my lord, again, to ensure this program, Food Security Act, again, there are designations, my lord.
All right, we'll issue notice, we'll examine.
Yes, my lord. My lord, these
We cannot go in
officers
detail
might,
as of now.
might have got confused because of these two designation in this Food Security Act.
How can
And
the state say they got confused?
therefore, I will seek instruction in what capacity. However, the cancellation has been done.
We'll issue notice making it returnable at short date.
Yes, my lord.
Huh?
And then
And in the meantime, we will not appoint a
Yes, my lord.
new, what do you call this? Fair price shop.
Yes, my lord.
Well, I will clarify, my lord. Whatever it may be, my lord, he says not below very well, but in a district. But who is the highest authority in the district? It is the deputy commissioner. Deputy commissioner issued the impugn order, my lord. There's no question of not taking away appellate forum. It is not the ADC who has issued the impugn order. It's a recommendation. The impugn
No,
order is
whether
by
the question again is whether the appellate authority has to be restricted within
Yes, my lord, because it
that
says-
same district itself.
Yes, yes. The state government shall appoint an officer of that government not belong the rank of an initial district magistrate of a district.
Yes, my lord.
Yes, an appellate authority.
Not
Obviously, the deputy commissioner, nobody is above the deputy commissioner in the district
It says
of
officer.
a district as an appellate authority. And this designated authorities also. The food and civil supply officer is also different manner. There are supply inspector in the department. They must be referring to this. It says inspector.
Who are they in the district level otherwise?
Manner.
In district
There's
level,
a,
supply
there's a
officer,
supply officer, and then there are supply inspectors are also there.
supply
It says food and
inspector,
civil supply
storekeeper and all that.
inspector. I don't know essentially if it is
District.
equivalent to the.
Are they
supply
taken
officer
care
or-
of by the office of the deputy commissioner itself regarding supply?
Supply, yes.
No, supply department is there, isn't it? Separate.
Supply department is there.
So
Under in the
don't-
district, they are,
Don't they have a separate officer there in the district level also?
yes.
Or is it the deputy commissioner and his assistant or additional DC who takes care of the supply
No,
department?
food and civil supply officer. District food and civil supply.
You have
Yes,
food and civil supplies officer.
yes, district food and civil.
So why have they not acted upon it?
My lord, that's why who is the designated authority that
I am
has to
sure
come.
they said-
No, no,
when
no.
it's
That
not
has
done
to
it.
come, my lord.
See, normally when it's regarding supply, now who has issued this license in the first place?
License has been issued by the deputy, he's the licensing authority.
Who?
Deputy commissioner. They're way back in
Okay.
1990.
As of today, it is also the deputy commissioner.
As on
That
today-
instruction I'll have to take, my lord. As on today also, it should
I
be
think
the-
so, ma'am. Just a moment, my lord. There's a new. I don't think it's the deputy commissioner anymore, my lord, page 51. It is now under the food safety and standards.
So either way, we can trash it out at an
Yes.
early date. Mr. Ratan
some other authority, it seems now. Because the registration has also been changed, mine also, 2015.
No, if you have the Food and Civil Supplies Officer of Directorate,
Yes.
they are supposed to take care of all these things.
It appears so because.
Deputy
page 51
Commissioner may step in the absence of any such kind of departmental officer.
After this Food Security Act came, it
In a
appears that-
district, he's an overall head. Deputy Commissioner is an
Yes,
overall
ma'am,
head.
yes.
All right. Heard Mr. D. Pangi, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the order dated 15/8/2023 within bracket annexure 8 passed by the Deputy Commissioner. Just a minute, see. Both of you just see this annexure is not legible.
Yes, madam. Because I have a type copy at page.
Ah. But then in the type copy, you have said DFCSO, Bomdila District Food and Civil Supplies Office, and followed by Office of Deputy Commissioner. Is he functioning dual?
It is like that only. It is written like that here. Bomdila
No,
district.
that is why I put up, that is why I put up that question to you all.
That
Is
is
there
how-
no separate supply officer, supply office
There is,
and
ma'am.
DC?
There is. I don't know how they have done.
If there is, then why all these are coming together?
That's why, but apparently, my lord, the authorities there are all confused.
Please read what I've dictated. No, read from the beginning. Within bracket annexure 8, passed by the Deputy Commissioner, West Kameng District, Bomdila, whereby the FPS license given to the FPS license of the petitioner has been cancelled with immediate effect. To stop, the learned counsel submits that acting upon certain complaint submitted to the additional Deputy Commissioner NAFRA, the state authority conducted a summary hearing of the complaint and thereafter submitted a report to the ADC headquarters, DGRO, West Kameng District, Bomdila, recommending the cancellation of the FPS license of the petitioner. To stop acting upon the same, the impugn order dated 15/8/2023 has been issued.
First manner 24/7 was issued, passed.
What is that?
Page 57. Same thing, same summary proceedings, and he recommends the ADC headquarters.
Who is this? ADC headquarters.
Page 57.
Then from acting upon, you cancel. Please rewrite. Acting upon the recommendation, what is this authority?
Additional Deputy Commissioner come District Grievance Redressal Officer.
Additional Deputy Commissioner come District Grievance Redressal Officer. Of which place?
This is, my lord, under a different act, my lord. That's why I was submitting that all confused, I mixed it up. West has to be West Kameng, my lord.
Of West Kameng District, Bomdila, white order dated 24/7/2023.
Page 60 is the recommendation.
came to a finding that the petitioner has committed irregularity by not following the guidelines of TDPS, TPDS. And recommended the cancellation of her license. Her, is it? His license. Full stop.
Under section, my lord, if this.
It's okay. Then it was further recommended that till such time of appointment of new FPS, the TPDS consumers may be allowed to draw their ration from FPS number 1, Nafra. Yours is what? Number?
My lord,
You have a number?
my lord, that I'm not sure of it. They have not mentioned anything. My lord. I will find it out. But obviously this is something else, my lord. FPS number 1.
No, there must be a
Yes.
FPS,
There
other FPS.
Yes, there must.
So some arrangement is made.
Yes, yes.
To stop. Thereafter, the Deputy Commissioner, West Kameng District, Bomdila, passed the impugn order dated 15/8/2023. Next para. The Learned Counsel submits that the petitioner was neither furnished a copy of the complaint submitted against her, nor was she given adequate opportunity to be heard prior to issuance of the impugn orders. Full stop. He submits that as per the targeted public distribution system within bracket control order, 2015, which is framed in exercise of the powers conferred by Section 3 of the Essential Commodities Act, 1955. The designated authority who is an officer not below the rank of Inspector of Food and Civil Supplies can take action in respect of violation of any condition of the license, including any irregularity committed, which may include suspension or cancellation of the fair price shop owner's license. Full stop. The appellate authority, as defined under Order 15, under Clause 15, provides that the state government shall appoint an officer of the government who is not below the rank of additional district magistrate of a district as appellate authority. And the state authority is authorized to consider and dispose of the appeal. Full stop. However, in the instant case, the Deputy Commissioner himself has cancelled the FPS license of the petitioner. And therefore, the petitioner has been deprived of the forum to file an appeal. To stop. He therefore submits that the impugn order dated 15/8/2023, as well as the order dated 24/7/2023 may be set aside. Next para, in view of above, issue notice of motion returnable by 3 weeks, Mr. N. Ratan, learned additional AG, accept notice on behalf of all the respondents. Requisite extra copies of the writ petition be furnished to him. To stop, having regard to the rejection made by the petitioner, the impugn orders dated so and so and so. Just right. Impugn orders dated 24/7/2023 within bracket annexure 7, and the order dated 15/8/2023 within bracket annexure 8 shall remain suspended till the next returnable date. To stop, considering the fact that the distribution of essential commodities of the area concerned,
I think they have already made arrangements. I believe. That arrangement.
what arrangement?
Constitute a board to distribute the food items.
This is for which month? This is for 1 month only, August. Then what will happen in September?
I believe they will do next month something.
Huh?
Most probably this next month they will take fresh steps, I guess. I understand that. This is for the month. I think monthly these lessons comes. So for this month, they have done this. So next month maybe they will do something similar.
So I don't think I need to make any observation.
But let it be. They will take care of themselves. Only indicate that in the meantime not to appoint any new, but
distribution of
state.
It's already state now.
Already state. That will again create, because
it's not clear enough or what? When I say state, they will still appoint.
no, that distribution part, my lord.
Distribution part. So that's why I was asking you what to do with the
distribution part. Maybe as continued in the at page 60 in the order of the ADC NAFRA. Page 60.
60?
Yes, page 60.
But that we have stated actually.
That might be clear. State.
Okay, then I think we'll just say this cancellation only.
Yes.
Okay, what did I say? Then the impugn order. What else? No, before that, what did I say? Yes. That you cancel. The impugn order dated 24/7/2023 and extra 7 that you cancel. Only the impugn order dated 15 August 2023 and extra 8 shall remain state till the next returnable date. So it is further directed that the respondent authorities concerned shall not proceed to appoint a new FPS, a new fair price shop to replace the petitioner. To stop the distribution of the essential commodities shall be carried out in the manner as per the arrangement made by the ADC cum DGRO. List the matter again after 3 weeks. Problem. Yes.
My lord, the petitioner is aggrieved by the action of the respondent authorities in extending suspension order periodically, your lordship.
Sorry?
The petitioner, who was working as personal assistant, your lordship, under the Public Service Commission, your lordship, he had been suspended, your lordship, by order dated 29/10/2022, your lordship. It has been annexed at Annexure 1, page number 27.
Okay.
My lord, what has happened in this case is that pursuant to some allegations against unfair practices that has.
Pull the mic just near you. Yes.
My lord, in terms of some allegations, your lordship, regarding unfair selection process conducted by the Arunachal Pradesh APPSC, your lordship, the petitioner who was working as personal assistant, he had been put under suspension, your lordship, by this order.
Okay.
And thereafter, your lordship, the respondent authorities by order dated 22/5/2023, your lordship, that is annexed at Annexure 4, page number 32. They have extended it for a period of 180 days, your lordship, without providing any reasoned order or by issuing a memorandum of charges, your lordship. And another order was also issued on, which is on next page, your lordship, page number 33. By this order, that is on 10th August 2023, which has been signed on 14th of this month, your lordship, the suspension period of the petitioner was also extended for a further period of 90 days, your lordship. The petitioner is before your lordship challenging these orders on the ground that this suspension order could not have been extended, your lordship, for further periods of 90 days and 180 days, your lordship, on the ground that it is in violation of the section 10 or rule 10C of, I'm sorry, your lordship, rule 10(6) of CCS rules, your lordship, and also on the ground that it is in violation of the directions issued by this honorable court, Supreme Court, in the case of Ajay Kumar Singh, your lordship, Ajay Kumar Chaudhary.
You have the Ajay Kumar Chaudhary?
Yes, your lordship. 2015, volume 7, page number 291. Paragraph 21, your lordship, 20, 21.
What does it say?
My lord, in terms of this judgment, your lordship, the honorable court has held that suspension cannot be extended periodically without providing a memorandum of charges, your lordship. And it has to be provided within a period of 90 days, your lordship, within a period of 3 months. And the suspension had, the continuation order had to be a recent order, your lordship. The petitioner is also challenging these orders on the ground that these orders are passed in violation of Rule 10(6) of CCS rules, your lordship, which specifically provides that in case the orders have been reviewed, your lordship, it has to be done within a period of 90 days.
Do you have a copy? CCS?
Yes, your lordship.
Just read what you want. Relevant portion.
One of the relevant portion is that I'll be relying on clause subsection sub rule 6, your lordship.
Yes.
Of rule 10. It says that an order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before expiry of 90 days from the effective date of suspension on the recommendation of review committee constituted for the purpose and pass orders either extending or revoking the suspension. Subsequent reviews shall be made before the expiry of the extended period of suspension. Extension of suspension shall not be for a period exceeding 180 days at a time.
So what is, according to you, has not been followed here?
My lord, this order that has been annexed, your lordship, at annexure 32, annexure 4,
Yes.
page number 32, and as well as annexure 5, page number 33, your lordship.
Mm.
It shows that though a review committee was constituted, your lordship, and the order has been reviewed, your lordship, but however, this review was done after a period of 7 months after the passing of the suspension order, your lordship, and this could not have been done
The
by.
first suspension.
Yes, your
7
lordship.
months after the first
After
suspension. 29th October was the date.
It was
Then the next date is 23rd of
22nd May 2013, and the next review was done on 10th August 2023, your lordship.
So it was more than after 6 months.
Yes, your lordship. And this could not have been done. And what
And
has
between
been,
the second and third,
yes, your 22nd May 2023 and 10th August 2023.
but the third one is within time, isn't it?
Yes, your lordship.
But between the first and the second, there was about 7 months.
Suspension was done in the year 2022 in the month of October, and
Mm.
this review was done in the month of May, your lordship, which was
Yeah.
after a period of 7 months, and then the second order extending the suspension was carried in the month of August, your lordship,
August.
after a period of 3 months,
Hmm.
which was also not permissible, your lordship.
Yes. Government side.
This say notice by issue.
Without charge sheet, how can you go on like that? Ajay Kumar Chaudhary says
No,
that.
it need instructions.
Huh?
Need instructions.
When can you get instructions?
No, sir.
When can you get instructions?
1 week.
A week's time. All right. Heard Miss
D. Tamuk.
D. Tamuk,
D. Tamuk, yes, your lordship.
learned counsel for the petitioner, who submits that the petitioner is aggrieved with her or his with his prolonged suspension, which is in violation of Rule 10 within bracket 6 of the CCS within bracket CCA rules,
1965.
1965, correct? And also in violation of the law laid down by the Apex Court in Ajay Kumar Chaudhary versus Union of India, 2015, 7 SCC 291. Next para, the learned counsel submits that the petitioner was initially suspended by order dated 29/10/2022. And after about 7 months thereafter, without issuing any memorandum of charge, his suspension was extended for a further period of 180 days, 180. To stop. Again, void order dated 10/8/2023, his suspension has been further extended for another period of 90 days. To stop. However, till now, the petitioner has not been served any memorandum of charge. Stop. As such, the impugned suspension orders should be set aside. Next para, issue notice of motion returnable by returnable by
2 weeks.
2 weeks. Mr. S. Tapin, learned senior government advocate, accepts notice on behalf of
1 to 3 laws.
respondent numbers 1,
1 to 3.
2, 1 and 3.
1 to 3 laws.
1, 2 and 3.
All correspondent number 4.
While Miss
And Anju.
N. Anju, learned counsel, appears for respondent number 4. So stop. Notice is therefore complete. Stop petitioner to furnish requisite extra copies of the writ petition to the learned counsels for the respondents. List the matter again after 2 weeks.
Obliged to.
Mayor, my lord.
Yes.
Fact of the case is that, my lord, the petitioners were in occupation of land measuring 481.41 acres. My lord. They are the landowners, my lord, the petitioners here. Now, what happened, my lord? The joint survey was, my lord, carried out, my lord. Page 46, my lord, over the land, my lord. In the joint survey, it was also found that a total area of 481.41 acres of land are in occupation of the Indian Army, my lord, who were in occupation since 1980, my lord. Though they were in occupation, they were not acquiring my land, my lord, our land, my lord. So why we filed a writ petition, my lord. Page 49, my lord. WPC 390 of 2015, my lord. Now, my lord, the relevant paragraph, my lord, page 55, my lord. Page 55, my lord. The last paragraph, my lord.
55.
55, my lord.
Yes.
Merit admittedly, last one. Admittedly, the army authorities are in occupation of land in question since 1980. No rent in respect of the land in question has been paid to the petitioner. No process of land acquisition has been started by the respondent authorities. It appears from the pleading state the petitioners are not ready to lease out the land either in short-term or long-term basis. In view of the circumstances, the respondent authorities may acquire the land as per the law laid down in so and so. That is New Land Acquisition Act, if they deem it fit, or they shall have to vacate the land in occupation on payment of reasonable compensation for their occupation since 1980. Now their occupation since 1980 has been established, my lord. It has attained finality, my lord. Now what happened, my lord? The land acquisition was initiated, my lord. In principle, approval was given page 57, my lord, by the central government, my lord. For 481.41 acres, my lord, of community land of the petitioners, my lord. Now what happened, my lord? Land acquisition process was initiated, my lord. The notification was issued by page preliminary notification page 67, my lord. Preliminary notification was issued, my lord, for acquisition of land of the petitioners, my lord. Now following the acquisition process, my lord, my land were acquired, my lord. Our land was acquired, my lord. Area around 202 acres was acquired, my lord. The final award is at page 76, my lord. Now by specific grievances, my lord. In the year 2022, they have acquired my land, my lord. But prior to that, my lord, they were in occupation of my land.
Acquired in 2021.
Yes, my lord.
Any date specific?
Specific, my lord, the preliminary notification was issued. First preliminary notification issued on 5/1/2021, month. Page 67.
This is under the 2013 Act or what?
Yes, 2013 Act.
Okay.
Yes. Now they have paid us the compensation amount, my lord. But my lord, from the period since 1980 to 2021, my lord.
2021 when?
Yes,
And
my lord.
1980 when?
1980, since 1980, my lord.
Date, month?
No, only year, my lord, 1980, my lord. Since 1980 till 2021, my lord.
For that period, you are demanding rent
Yes, right, my lord.
by this writ petition.
Yes, my lord.
Have you approached them?
Yes, my lord.
When? How?
By way of representation, my lord.
Where is that?
There is a page 77, my lord.
77.
Yes, my lord. On 23, 123. my lord.
What is this? Section 80?
No,
It's not-
no, section 80, my
It
lord.
is not a notice.
No, no.
It is a representation.
Representation, my lord. We
Where is
request
the area of the land? I mean, where is the land located?
LGG, my lord.
Huh?
LGG, Bomdir, Tawang district, my lord.
AGG.
LGG, my lord.
LGG.
Lungro, Glengrow, grazing ground, my lord. Yes. My lord.
Glen Grove.
Yes, ma'am. Lungro grazing ground, my lord. No.
Yes, who's appearing?
I'm on RL Jain, my lord. RL Jain, my lord.
What do you want to cite now?
No, but this is about my specific claim, my lord. The Supreme Court has my lord, settled the law. Let notice be.
Our notice will go.
Yes,
You are appearing?
I am appearing for respondent 1 to 4.
You are Central Government Council?
Yes, sir.
Okay, 1 to 4.
1 to
And Mr. Ratan will be
5 and 6, my lord.
Okay. So since 1980,
Yes.
I'm sorry, from in 2021,
Yes.
your land has been acquired.
Yes, ma'am.
But the thing is that you have paid for the land, but since 1980 to 2021,
Yes, ma'am.
your land being under occupation, you
Okay,
should
yeah.
be given some rent.
Yes, ma'am. My lord, in what happened on page?
So the fact of the compensation being given to the landowner petitioner
Yes.
for acquisition of land goes to show that land was occupied.
Yes.
It is his or her land. So why should rent not be paid? And if rent is to be paid, how it is to be assessed?
My lord, page 80, my lord. They once initiated, my lord, page 80, my lord, of my writ petition. Page 80, my lord. The deputy commissioner has initiated, my lord, but it was not materialized, my lord. Page 80, my lord. Student number 1, my lord. This is the Glen Grove, my lord, LGG. So and so, lease rate, my lord, 3 rupees, my lord. 1980 to 2007, my lord.
No, that is why I'm asking you, what is the basis? Any rent control act or something available in the state?
That's why, my lord. My lord, in certificate 1, my lord, down below, my lord, certificate 1, certified that the estimate lease rent has been worked out based on government approved rate by notification so and so, 18/9/2008, my lord. There is some.
Who has made this estimate?
Deputy Commissioner. Deputy
Under
Commissioner.
whose instruction?
But he being
On what basis?
he being the collector, my lord.
No, that is okay, but how he has made the assessment? Have you approached the deputy commissioner? Make assessment?
Yes, ma'am.
Where is that?
My lord, as per the.
You are only annexing this document, one
Yes,
page
ma'am.
document estimate.
Yes, ma'am. Let the notice go, my lord, in that case.
All right, heard Mr. Lee Bichal and counsel for the petitioners. Who submits that by filing this writ petition, the petitioners have claimed payment of rental compensation for the period with effect from 1980 to 2021. Since their lands have been occupied by the armed forces. Stop. The learned counsel submits that the location of the land is at
LGG, my lord.
LGG.
Yes.
Is at Lungro grazing ground.
Yes, my lord.
Tawang.
Yes, ma'am. District Tawang.
Stop. Just read the order. One before that. Just read from the beginning. Yeah. Has been occupied by the armed forces. Okay, okay. Stop. The learned counsel further submits that the land of the petitioners have otherwise been acquired by the army authorities in the year 2021, and for which compensation has been paid to them. Stop. However, rental compensation for the aforesaid period has not been paid, and therefore they are before this court. Next para. Issue notice of motion returnable by 4 weeks. Mr. What is your name? CGC?
M. Tanga, Your Lordship.
M.
Tanga.
M. Tanga. Learned CGC appears and accepts notice on behalf of the respondent numbers 1, 2, 3, and 4.
Yes.
Yes.
While Mr. N. Ratan, learned additional AG, appears for respondent numbers 5 and 6.
6, my lord. 5 would be D. Kamduk, my lord, standing counsel.
Okay, Mr. N. Ratan appears for respondent number 6. Where is Mr. Kamdu? He's not come. Have you served copy?
Yes, my lord.
When did you serve?
Yesterday only.
Okay. Has he come today, Mr. Kamduk?
Yes, he was there.
Mr. D. Kamduk, learned standing counsel, land management, appears and accepts notice on behalf of respondent number 5. You inform him, huh? Notice is therefore complete. Petitioners to serve requisite extra copies of the writ petition to the learned counsels for the respondents within 2 days. List the matter again after 4 weeks. Stop. Pendency of the writ petition shall not debar the respondents to consider and pay rental compensation to the petitioners as per the entitlement.
Much of it.
Be pleased, Your Lordship. So here in this matter, pleading is yet to complete, my lord. The state government has already filed affidavit. I have gone through it, so I would like to file reply, my lord.
How much time?
2 weeks may be given.
Okay, as paid for by the learned counsel for the petitioner, 2 weeks time is granted for filing reply affidavit to the affidavit of opposition filed by the respondents.
Yes. All right.
Well, the respondent authority, particularly deputy commissioner, has to file the affidavit.
Here, my lord, our affidavit is ready, my lord. I'll be filing within this week, my lord.
You were saying something?
We have to
Yes,
file affidavit.
deputy commissioner, my lord, has to file the affidavit.
Learned government advocate,
Correspond number 3 and 4, my lord.
Miss T. Wangmo,
Yes, ma'am.
submits that the counter affidavit is under preparation and she'll be able to file the same within a week. To stop in view of above, list the matter again after a week.
Obliged.
My lord, in this instant case, pleading was not completed. As many as there are 5 respondents, nobody filed affidavit till then. And extra copy
Was not served, my lord.
Extra copy are served today. Sorry, my lord.
All right,
Extra,
all right. As paid for by the learned government advocate, further 3 weeks time is granted for filing counter affidavit to stop the petitioner to petitioner to furnish extra copy of the writ petition to the learned government advocate.
Obliged.
Lordship, I'm for the petitioner, Lordship. Still, they are yet to file their affidavit, counter affidavit.
Yes.
We have already sent for the instruction. Yet to receive. So when thereafter additional affidavit was filed, but we have not received the extra copy.
Okay. 3 weeks. How much time will you get? 3 weeks, as paid for by the learned State Council. Further 3 weeks time is granted for filing counter affidavit to stop the petitioner to furnish extra copies of the additional affidavit filed on 19/7/2023 to the learned government advocate.
Much.
Yes.
Yes, my lord. This is a case, my lord, for the Indian Army are also in occupation of land, my lord, in Tawang district, my lord, but they are not paying. They are not acquiring the land, my lord. So why we have
Not acquiring.
not acquiring, my lord.
Since when?
Since once some areas since 1960s and some areas in 1980s, my lord.
Where is the place?
It is Tawang district, my lord.
Tawang.
Yes, my lord.
So notice can go.
Lordship, we have already received the instructions. And we'll be filing shortly, but Lordship, in this case, the affidavit of CGSC will be more needed than Army, because from our side, we have been trying. But
Yes. Have you received instructions?
No, Your Lordship, some more time may be given.
How much time? 3 weeks.
3 weeks.
3 weeks. Okay, as paid for by the learned State Council as well as by the CGC, appearing for the state respondents and Union of India respectively, comma, further 3 weeks time is granted for filing counter affidavit. List again after 3 weeks.
Obliged.
My lord, may I please. My lord, this is a highway regarding highway compensation matter.
This is what? Compensation matter?
Yes.
Compensation for what?
Highway 4-lane
Highway,
compensation. Yes.
highway construction.
Yes. My structure is pending. My structure is issued at Papunala Nahalagan, and assessment was done. And 1 crore 38 lakhs 37,284 has been fixed, and out of that I have received 24 lakhs 66,288 rupees, and remaining 1 crore 13 lakhs and 70,996 has to be released by the Deputy Commissioner. Now Deputy Commissioner is claiming that demolition, self-demolition has to be done first. Then only Deputy Commissioner is ready to release the remaining amounts. So last occasion, this Honorable Court was directed to obtain an instruction from the Deputy Commissioner, order dated 12/6/2023. The clearly direction was given. This court on 17/3/2023 directed the State Council to produce the following instruction. 1. The order of the approval whereby the estimate for self-demolition was given. Number 2, if the same is approved, why such payment has not yet been made to the petitioner? So last para, this is clearly directed. List this matter after a week so as to enable the learned government advocate to produce the relevant instruction as required to evoke on the next date, failing which this court will pass an appropriate order. So now let the learned council who represent a Deputy Commissioner give such instruction from the Deputy Commissioner.
Your Lordship, I'm sorry to inform you that we are unable to seek the instructions that is sought by this honorable court. Your
Why?
Lordship.
What is the reason?
Because
Deputy Commissioner is not cooperating. Or what?
somewhat they are not giving us the required inquired by this honorable court, Your Lordship.
Did you communicate this order?
Yes, Your Lordship.
So for this 4-lane construction of road,
Yes.
some acquisition was done,
Yes.
out of which you have been given 24 lakhs.
24 lakhs in his
And remaining balance is 1 crore
1
13
crore
lakhs.
13 lakhs 70,000.
And they are not releasing this because there is some construction.
Demolition, my structure, self-demolition had to be carried past.
Sorry?
Self-demolition of my structure had to be carried past. Then
Achha.
only Deputy Commissioner is ready to release the remaining.
No, but if it's acquired, then who will do that?
So
Your land is acquired. Your land has been acquired along with the building, is it?
yes.
So why don't you demolish it then? If it's already
As
acquired.
per law, compensation passed, then demolition can. So without receiving the compensation, the demolition cannot be done.
Your Lordship, the petitioner is challenging basically the order dated 18/9/21, where he was ordered to demolish his structure along the right of way, Your Lordship.
Where is the order? Page?
Page 18, Your Lordship, of the writ petition, Your Lordship.
Annexure 3.
1, Your Lordship.
Annexure 1. Page 18 is annexure 3. Annexure 1 is page 13. Detailed assessment report. Is it that one?
Your Lordship is reading from the additional affidavit.
No, from the writ petition. What have you challenged here? Which order? Any order?
Yes, I have challenged the order dated 18/9/2021.
No, this is an interlocutory order. Just a minute. This is the IA.
Yes.
Yes, Your Lordship, in the writ petition, Your Lordship.
In my writ petition, page number 18, annexure 1.
This is item, which item?
10.
Item 10, this is the one. Item 10 is IA 165.
Yes, is there in pending of the writ petition I was filed.
What is the writ petition?
Writ petition is of challenging the self-demolition order issued by the Deputy Commissioner dated 18 September 2021.
Dated
18/9/2021. Page number 18.
Is it available in the IA?
No, IA is not IA is the printing. IA is in pending of this writ petition. The Deputy Commissioner.
Where's the writ petition?
Deputy Commissioner.
Please send it. In the writ petition, page number?
Page number
18, Your Lordship.
18.
Yes, Your Lordship.
This is notice of self-demolition. Demanding for self-demolition of my structure. Thereafter, asked to receive the compensation.
Compensation is paid, assessed by under what provision?
Pardon?
Compensation is assessed under what provision of law?
In fact, the accusation process as per there is no such accusation as per Accusation Act.
Then what is the formula applied?
Your Lordship, in this regard, I would like, as far as my humble understanding, Your Lordship, the order dated 18/9/21 was issued in pursuance to the cabinet decision held on 9th June 2017, Your Lordship. It's in our affidavit, Your Lordship.
That is only cabinet decision, that is not the act.
See, this is, I don't think there's any such kind of acquisition. Disbursement of compensation, cum relief package for self-destruction of structures, assets, falling within right of way of National Highway 415. Papunala to Tri-Junction. So it's basically a relief package.
Yes, Your Lordship,
Isn't
because
There's no such formula. A relief package is given, okay, this much land, this much will be given to you. So where is the offer? On what basis is that calculation? 24 lakhs received, 1 point so and so crores not received. Where is the calculation?
In thereafter, after serving of this notice, I approached before the Honorable Court in a form of writ petition. In pending of this writ petition, the Deputy Commissioner approached me to collect the compensation. And I visited to the Deputy Commissioner. Deputy Commissioner offers me 1.38 lakhs. And out of that, I received 24 lakhs.
24 lakhs?
Yes, 24 lakhs.
No, you said Deputy Commissioner offered
1.38 lakhs.
1.38 lakhs.
Yes. Out of that, I received 24 lakhs.
1.38 lakhs.
Yes.
The crores. 1 crore, 0.38. 1.38 crore.
1 crore 38 lakhs.
And you've received 24 lakhs.
Yes.
How much is the balance now?
Remaining 1 crore 13 lakhs and above. 1 crore 13 lakhs is 70,000. Remaining is 1 crore 13 lakhs 70,996. $24 lakhs I received in the month of April 2022. And from the day of receiving the 24 lakhs initially, my structure is remain closed. And partially I demolished my partially some structure. That's why my daily earning working hotel is remain closed till now. Neither the deputy allow me to run my hotel nor release the remaining pending compensation amount.
So in this writ petition, you've challenged this notice. Correct.
Yes.
Now, on what basis have they offered you that money? It is as per mutual agreement.
No such agreement, just asking me to visit the office. Accordingly, I visited. And when I visited, Deputy Commissioner offered me to 1 crore 38 lakhs. Otherwise, he will remove my structure. On pretext of that, on threatening, I received 24 lakhs. And he started my self-demolition.
You're agreeable to receive 1.38 lakhs. You're agreeable.
Remaining as per offer from the Deputy
No,
Commissioner.
forget remaining and all that. You're agreeable for 1.38 lakhs.
Yes.
Isn't it?
Yes.
If you get that amount, you don't mind if the structures are removed.
Yes.
Now, who should remove the structures?
If the as per verbal agreement, if the Deputy Commissioner release entire amount as per agreed, self I will remove.
Now,
my
where is
structure.
that agreement?
No, Your Lordship,
Agreement is not there as per
we have never-
reply.
Where is the agreement?
No such agreement.
Then,
But same is admitted in their affidavit in reply in my I-65, 165. Para number 4. Page 4, para 4.
No, Your Lordship, we have not agreed in that.
Now, how do you implement this? There is no such agreement as such.
Yes, Your
It's a negotiated rate. Negotiated rate.
No, Your Lordship, it's as part of cabinet approval date, meeting dated 9 June 2017.
No, cabinet approval means cabinet also will have to determine what is the formula applied.
Yes,
Because there are not only the petitioner, there are others also, I think.
yes, everybody has complained.
So depending on the size of your land, depending on the structures which is on the way, the amount will be less and more, like, isn't it?
Your Lordship.
So what is that formula applied?
May I take Your Lordship to our affidavit, Your Lordship? Respondent number 3, Your Lordship. Page number 23, Your Lordship, Annexure H.
Just a minute. So what do you say about this order? This is already an order. Order of approval whereby the estimate of self-demolition was given. If the same is approved, why such payment has not been made?
No, Your Lordship, he has not demolished the entire structure which comes within the right of way, Your Lordship.
That we have understood.
Yes, Your Lordship.
We are asking you the order of approval where estimate of self-destruction was given. Where is that order?
It's in this order only, Your Lordship. Cabinet
Which
approval
order?
In our
Where?
affidavit, Your Lordship.
Which affidavit?
By respondent.
Then if it is there in the affidavit, why this order was passed on 12/6? You were there.
Your Lordship, I'm not getting Your Lordship.
You are Mr. What is your name?
Wairi Ram, Your Lordship.
Wairi Ram.
Yes, Your Lordship.
On 12/6/2023, you were present in the court.
Yes, Your Lordship.
In your presence, this order was passed to produce the order of approval.
Yes, Your Lordship.
And now you're saying that it's already there in the affidavit. If that is the thing, then you should have told the court, it's there in the affidavit.
Yes, it was my
Huh?
on fault on my part, Your Lordship.
So where is the order? Show me.
No such order, Your Lordship. I failed to get that order, Your Lordship.
No, you are about to point out, it is already there in the affidavit, you said.
Yes, in our affidavit, Your Lordship.
Where? Which affidavit?
Respondent number 3, Your Lordship.
Page?
23, Your Lordship. Annexure H, Your Lordship.
Page 23.
Yes, Your Lordship.
There is no page 23. Additional affidavit. Or
No, Your Lordship, in the writ.
Reply to 165. Reply.
Page?
Page 23, Your Lordship.
Order.
Yes, Your Lordship.
5th July.
5th July, Your Lordship.
What does it say?
It says in serial number 2, Your Lordship, compensation cum relief package shall be provided only to the owners of the structures who will carry out self-demolition of their structures within ROW of the existing 415, NH 415. In the case of the petitioner comes under.
No, apart from this, the estimate is required, isn't it?
Yes, Your Lordship.
Where is the estimate?
It's in the 24, page number 24, Your Lordship.
No, this is generally for RCC building this much.
Yes, Your Lordship.
Now, who has done the calculation and who has given the approval? That is what we want. 17-3.
Then Your Lordship, may this matter be adjourned to the Your Lordship, then be posted for
No,
tomorrow.
let us try to understand what the matter is about. Let's see. Just as far as the number 2 is concerned, answer is already there, isn't it? That first you have to
Yes,
self-destruct, then will self-demolition should be done, then we'll give you the money.
Yes, Your
But
Lordship.
what about the number 1? Because this is the guidelines only. The cabinet minister's decision is a guideline
Yes, Your Lordship.
for this kind of building, this much square meters, this much amount should be paid. So who has done the calculation?
It was a board was constituted, Your Lordship, and as per the verification, site verification.
So you produce that.
Yeah.
The board calculation I have enclosed in my IA.
Where?
Page number 13.
13.
Yes, in my IA.
This entire calculation is done in respect of your petitioner.
Yes. In pending of this writ petition, I file application before the Deputy Commissioner for sending assessment team. Accordingly, board was constituted.
What is this amount? 64 lakhs.
This is only some floors only.
So where is the remaining?
As per on the basis of this calculation, in my calculation, 2 crore 63 amount comes up. As per my calculation, but Deputy Commissioner denied.
See, Mr. Counsel, I don't know what you're saying. You are saying that you went to the Deputy Commissioner's office and you were offered 1.38, 1 crore 38 lakhs.
38 lakhs.
But now you're showing me a calculation which is only 64 lakhs.
As per there, this is only two floors only. 64 is only 2 floors.
Okay, then where is the remaining?
Remaining is page number 18 in my calculation. Page number 18.
How can it be your calculation?
Here, Lordship, here I have this. My structure is consisting of 6 floors. Only here indicate only 2 floors. If we calculate ground floor to up to the 6th floor, it's come up 2 crore 63. 2 crore 63 is my whole calculation, whole claim. And in regarding that, the Deputy Commissioner only offered 1.
That is your calculation.
Yes.
Are they going to pay you as per your calculation?
Yes. This is basing on the board site inspection by the team. Anyhow, though my calculation is 2.63 and Deputy Commissioner ready to pay 1.38, and out of that I have received 24 lakhs. So remaining amount may be directed to release.
It cannot be just like that. You see, both of you agreed to something. How do we? Unless there's an agreement, there's a sanction order, approval order that this is the amount which is agreed to be paid. How do we direct? You are Mr. Riram.
Yes, Your Lordship.
As prayed for by Mr. Y. Riram, the matter stands adjourned for 2 weeks to enable him to obtain instructions in terms of the order dated 12/6/2023 as well as 29/6/2023. Try to find out.
Yes, Your Lordship.
My lord, in this matter, though my name is reflected here first Uttam Dekka, but A.K. Purkast, the brief is with Mr. A.K. Purkast, my senior. So he instruct me over phone that on 22/9, 22nd September, he instructed me to pray before your lordship to adjourn today, and it may be fixed for admission by fixing 22nd of September.
You are Mr. C. Modi.
I'm Uttam Dekka.
Sorry?
You Dekka, Uttam Dekka.
Oh, you Deka.
Yes, my. The matter pertaining to termination of service.
Now, who's appearing for the respondents?
Respondent, Mr. Learned Brother Tagum Zamu, he instruct me that whatever that the honorable court fixed today, he is agree. He will be available on 22nd. He also agreed, my lord.
Right. As paid for by the learned counsel for the petitioner. List the matter again on 22nd of September.
All that.
May I please, your lordship?
Yes.
Lordship, in this matter, lordship, I have been instructed to appear for the respondent number 4, lordship.
You are Mr. Jitarak.
Tigaram, lordship.
Tigaru.
Lordship. So we will be filing our affidavit, lordship, counter affidavit, lordship. 4 weeks time, we will be able to us.
4 weeks. As paid for by Mr. Tigaram, learned counsel, who appears for respondent number 4. 4 weeks time is granted for filing counter affidavit.
There's an interim order that may be continued.
What is the interim order?
After subsequent to my appointment, my lord, a non-departmental minister, he initiated a UO note requesting my appointing authority to cancel my appointment.
All right. Till the next date, the interim order passed on 30/6/2023 shall continue.
Obliged.
Obliged.
ऊपर से हम सामान लेके आ रहे हैं
वो भी कॉल किया